Ada pendekatan keilmuan yang integratif, holistik, kolaboratif, dan aktif. Di samping itu, semua yang dirancang dalam kurikulum adalah dalam rangka pengembangan kemajuan mahasiswa.
Saya Satrio
pendekatan
Pranowo.
keilmuan yang
hari ini
integratif,
saya
holistik,
akan
kolaboratif, dan aktif. Di samping itu, semua yang dirancang dalam kurikulum adalah dalam rangka pengembangan kemajuan mahasiswa.
Di Kabupaten Pacitan.
Mahasiswa program doktor wajib menempuh 42 SKS dan mengikuti perkuliahan secara hibrid atau gabungan tatap muka dan daring secara bersamaan untuk memastikan perkuliahan dapat diakses dari mana saja, serta mempublikasikan hasil penelitiannya pada jurnal nasional dan internasional bereputasi.
Hello everyone, my name is Roja. I'm from Madagascar and I'm a doctoral student at Universitas Muhammadiyah Surakarta now. I have a great experience to tell you today. I was really amazed that I have many classmates that are very collaborative and are really willing to exchange along my study process. This is a very good key for a doctoral student because a doctoral study really needs motivations, because it's a very long journey. Apart from that, we have a very well-skilled lecturer at Universitas Muhammadiyah Surakarta that are very engaged to help students in their findings, researches, and legal studies. Apart from that, this Department of Law at Universitas Muhammadiyah Surakarta has a prophetic and transcendental basis.
السلام عليكم ورحمة الله وبركاته. أنا آية محمد من مصر. أنا بدرس في جامعة المحمدية سواركارتا. درست هنا قانون، ماجستير في القانون، وحاليا بكمل دكتوراه في القانون. الحمد لله أنا مبسوطة إن أنا في دولة إندونيسيا، لأن العلاقات الدبلوماسية بين مصر وبين إندونيسيا قوية، وهي مثال جيد للعلاقات الدولية الدبلوماسية. ولأن إندونيسيا ومصر دولة إسلامية، فأنا حاسة بالأمان هنا ومبسوطة لوجودي هنا. التعامل بين البروفيسور مع الطلبة الأجانب الحمد لله تعامل جيد جدا، وفي مساعدة مع اختلاف اللغات. لو بنواجه أي صعوبات باختلاف اللغة بيكون في مساعدة من البروفيسور، وبيكون في مساعدة من الطلبة المتواجدين معنا في الفصل. أنا مبسوطة جدا وأتمنى إن كل زمايلي يكون ليهم فرصة إن هم يجوا دولة إندونيسيا ويزوروها ويتعرفوا على الثقافات المختلفة، وإن هم يلاقوا فرصة جيدة للدراسة في جامعة المحمدية، لأن هي من الجامعات المشهورة جدا هنا، وهي سلسلة كبيرة جدا في إندونيسيا. وشكرا.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera untuk kita semua. Saya Dr. Indwaan, Sarjana Hukum, Magister Hukum, Rektor Universitas Muhammadiyah Demak, sekaligus alumni program Doktor Ilmu Hukum Universitas Muhammadiyah Surakarta. Ucapan selamat dan sukses atas kemajuan Universitas Muhammadiyah Surakarta secara umum dan program doktor Universitas Muhammadiyah Surakarta. Sebagai alumni program doktor Universitas Muhammadiyah Surakarta, saya merasa bangga sekali pernah dididik, diberikan pembelajaran yang begitu banyak. Terhadap saya, karena itu saya menyampaikan ucapan terima kasih yang setulus-tulusnya dan setinggi-tingginya.
Kegiatan akademik mahasiswa juga ditunjang oleh pelayanan yang optimal dalam rangka meningkatkan kualitas lulusan berupa pendampingan penulisan jurnal internasional bereputasi serta kegiatan klinik bimbingan disertasi yang mendorong mahasiswa agar lulus tepat waktunya. Sebagai usaha untuk merespon dan mengapresiasi perkembangan ilmu hukum yang berkembang pesat, dibutuhkan tenaga-tenaga terdidik yang berkualifikasi dan kompeten guna meningkatkan kualitas sumber daya manusia yang memiliki keunggulan secara terukur dan frontier dalam pengembangan ilmu hukum.
Assalamualaikum warahmatullahi wabarakatuh. Saya Profesor Dr. Kli Wardiono, Dekan Fakultas Hukum Universitas Muhammadiyah Surakarta. Fakultas Hukum merupakan salah satu dari 12 fakultas yang ada di Universitas Muhammadiyah Surakarta. Sebagai bagian dari perguruan tinggi Muhammadiyah, Fakultas Hukum mengemban visi untuk mengembangkan hukum dan ilmu hukum berbasis nilai-nilai keislaman. Untuk itulah, sebagai bagian dari Fakultas Hukum, maka program Doktor Ilmu Hukum Fakultas Hukum Universitas Muhammadiyah Surakarta juga mengemban visi untuk mengembangkan hukum berbasis nilai-nilai keislaman, yang secara spesifik disebutkan mengembangkan hukum berbasis nilai-nilai transendental.
Melalui aktivitas penelitian disertasi secara mandiri dan mendalam, dengan memperhatikan grand design, orisinalitas, dan kualitas penelitian, tujuan pendidikan program doktoral kami adalah 1. Menghasilkan lulusan yang memiliki kemampuan mengorganisasi penelitian dan pengembangan ilmu hukum secara kritis dan mendalam. 2. Menghasilkan lulusan yang memiliki etika dan moral, serta berpengetahuan luas sebagai frontier di bidang ilmu hukum. 3. Menghasilkan lulusan yang memiliki kemandirian akademik, inovatif, kreatif, dan progresif. Setiap penelitian disertasi diuji dalam ujian terbuka yang dipimpin oleh Ketua Senat atau Rektor beserta Dewan Guru Besar Fakultas Hukum. Program Studi Doktor Ilmu Hukum UMS memiliki tim pengajar profesional, para guru besar, dosen tamu bertaraf nasional dan internasional.
Program Doktor Ilmu Hukum Fakultas Hukum Universitas Muhammadiyah Surakarta telah memberlakukan kurikulum yang mutakhir yang didasarkan pada perkembangan ilmu pengetahuan dan teknologi serta standar KKN level 9 dengan berdasarkan pada keberlanjutan proses pembelajaran yang partisipatif, produktif, dan menekankan pada pendekatan keilmuan yang integratif, holistik, kolaboratif, dan aktif. Di samping itu, semua yang dirancang dalam kurikulum adalah dalam rangka pengembangan kemajuan mahasiswa.
Saya Satrio Teguh Pranowo. Dalam hari ini saya akan melaksanakan ujian terbuka untuk memperoleh gelar doktor dengan judul penegakan hukum terhadap kejahatan seksual terhadap anak berbasis transendal di Kabupaten Pacitan.
Mahasiswa program doktor wajib menempuh 42 SKS dan mengikuti perkuliahan secara hibrid atau gabungan tatap muka dan daring secara bersamaan untuk memastikan perkuliahan dapat diakses dari mana saja, serta mempublikasikan hasil penelitiannya pada jurnal nasional dan internasional bereputasi.
Hello everyone, my name is Rota. I'm from Madagascar and I'm a doctoral student at Universitas Muhammadiyah Surakarta now. I have a great experience to tell you today. I was really amazed that I have many classmates that are very collaborative and are really willing to exchange along my study process. This is a very good key for a doctoral student because doctoral study really needs motivations because, you know, it's a very long journey. Apart from that, we have a very well-skilled lecturer at Universitas Muhammadiyah Surakarta that are very engaged to help students in their findings, researches, and legal studies. Apart from that, this university, this Department of Law at Universitas Muhammadiyah Surakarta has a prophetic and transcendental basis.
السلام عليكم ورحمة الله وبركاته. أنا آية محمد من مصر. أنا بدرس في جامعة المحمدية سواركارتا. درست هنا قانون، ماجستير في القانون، وحاليا بكمل دكتوراه في القانون. الحمد لله أنا مبسوطة إن أنا في دولة إندونيسيا لأن العلاقات الدبلوماسية بين مصر وبين إندونيسيا قوية وهي مثال جيد للعلاقات الدولية الدبلوماسية. ولأن إندونيسيا ومصر دولة إسلامية فأنا حاسة بالأمان هنا ومبسوطة بوجودي هنا. التعامل بين البروفيسور مع الطلبة الأجانب الحمد لله تعامل جيد جدا وفي مساعدة مع اختلاف اللغات لو بنواجه أي صعوبات كاختلاف اللغة بيكون في مساعدة من البروفيسور وبيكون في مساعدة من الطلبة المتواجدين معانا في الفصل. أنا مبسوطة جدا وأتمنى إن كل زمايلي يكون ليهم فرصة إن هم يجوا دولة إندونيسيا ويزوروها ويتعرفوا على الثقافات المختلفة، وإن هم يلاقوا فرصة جيدة للدراسة في جامعة المحمدية، لأن هي من الجامعات المشهورة جدا هنا، وهي سلسلة كبيرة جدا في إندونيسيا. وشكرا.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera untuk kita semua. Saya Dr. Indwan, Sarjana Hukum, Magister Hukum, Rektor Universitas Muhammadiyah Demak, sekaligus alumni Program Doktor Ilmu Hukum Universitas Muhammadiyah Surakarta. Ucapan selamat dan sukses atas kemajuan Universitas Muhammadiyah Surakarta secara umum dan program doktor Universitas Muhammadiyah Surakarta. Sebagai alumni program doktor Universitas Muhammadiyah Surakarta, saya merasa bangga sekali pernah dididik, diberikan pembelajaran yang begitu banyak. Nah, terhadap saya, karena itu saya menyampaikan ucapan terima kasih yang setulus-tulusnya dan setinggi-tingginya.
Kegiatan akademik mahasiswa juga ditunjang oleh pelayanan yang optimal dalam rangka meningkatkan kualitas lulusan berupa pendampingan penulisan jurnal internasional bereputasi serta kegiatan klinik bimbingan.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. The Honorable Professor Supriyono, as Vice Rector of Universitas Muhammadiyah Surakarta, the Honorable Mrs. Wardah Yusfin, Doctor of Philosophy, as Vice Dean of Faculty of Law, Universitas Muhammadiyah Surakarta, the Honorable Mrs. Diana Setiawati, Law Legal Master, as the Chairman of the ICRTLAW Committee, Faculty of Law, Universitas Muhammadiyah Surakarta, the Honorable, our wonderful keynote speakers today, Professor Trisha Rajput from School of Business, Economic and Law at the University of Gothenburg, Professor Minhao Benjamin Shen from Faculty of Law, University of Hong Kong, Professor Ginny Patterson from Melbourne Law School, University of Melbourne, and Professor Aidul Fitri Siada from Faculty of Law, Universitas Muhammadiyah Surakarta. And of course, last but not least, the honorable guests and audience. Ladies and gentlemen, we would like to extend a warm welcome and express our gratitude for participating in the third International Conference Restructuring and Transforming Law 2024. I am Giza Sharifa, will be the master of ceremony of this event today. Ladies and gentlemen, ICRTLAW, or International Conference Restructuring and Transforming Law, proudly presents by the Faculty of Law, Universitas Muhammadiyah Surakarta. Every year, every conference features a theme that represents the most recent issues as determined by experts in various professions. Through this day, May 8, 2024, we will be learning from our four prominent keynote speakers, which came from different countries. Well, ladies and gentlemen, now I would like to read the list of agenda today. The first agenda is opening. The second agenda is singing national anthem Indonesia Raya and Mars Muhammadiyah. The third agenda is reciting Holy Al-Quran. The fourth agenda is speech from Vice Dean, Vice Rector of Universitas Muhammadiyah Surakarta. The fifth agenda is speech from Vice Dean Faculty of Law, Universitas Muhammadiyah Surakarta. The sixth agenda is seminar session, and the last agenda is closing. For the next agenda is singing national anthem Indonesia Raya and Mars Muhammadiyah. To all of the participants, please turn off your microphone. Now, the third agenda is reciting Holy Al-Quran. It will be read by Mr. Gilang Rahmat Alam. For Mr. Gilang Rahmat Alam, time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. الرحمن علم القرآن خلق الإنسان علمه البيان الشمس والقمر بحسبان والنجم والشجر يسجدان والسماء رفعها ووضع الميزان ألا تطغوا في الميزان وأقيموا الوزن بالقسط ولا تخسروا الميزان والأرض وضعها للأنام فيها فاكهة والنخل ذات الأكمام والحب ذو العصف والريحان فبأي آلاء ربكما تكذبان خلق الإنسان من صلصال كالفخار وخلق الجان من مارج من نار فبأي آلاء ربكما تكذبان صدق الله العظيم. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much for Mr. Gilang. May we all get syafaat in this life and hereafter. Amin ya rabbal alamin. Ladies and gentlemen, for the next agenda is opening speech from Professor Supriyono as Vice Rector of Universitas Muhammadiyah Surakarta. For Professor Supriyono, now time is yours.
Thank you. Dear all, can you hear my voice?
Yeah, yes, sir.
Is clear? It is clear?
Clear.
Thank you. Ladies and gentlemen, good morning and welcome to the third International Conference on Restructuring and Transforming Law. I think it is my honor to stand before you and extend my warm welcome to all distinguished guests, legal practitioners, academics, and stakeholders who have gathered here today. As we embark on this significant journey, themed AI and legal innovation in the tax revolution, rights, regulations, and responsibilities, we are presented with a unique opportunity to delve into the integrated relationship between artificial intelligence and the legal landscape. The convergence of AI and the legal domain has brought forth a myriad of challenges and opportunities that necessitates our collective attention and constant efforts. Artificial intelligence, with its remarkable capabilities, has revolutionized various sectors, including the legal realms. Its integration into legal processes has led to unprecedented advancement, streamlining operation, enhancing efficiency, and augmenting decision-making processes. However, amidst the promises of innovation and progress, we are confronted with a multitude of legal, ethical, and societal implications that warrant careful consideration. The overarching theme of this conference underscores the imperative to comprehensively examine the impacts of AI on legal developments. It calls upon us to navigate through the intricate web of rights, regulation, and responsibilities that accompany the proliferation of AI technologies. As guardians of justice and equity, it is incumbent upon us to ensure that the deployment of AI in the legal domain upholds fundamental rights, fosters transparency, and promotes accountability. Throughout the course of this conference, we are presented with a unique platform to engage in substantive discussion, exchange valuable insights, and cast a path forward toward a more inclusive and equitable legal framework. It is my fervent hope that our deliberation will yield actionable strategies and innovative solutions that reconcile the transformative potential of AI with the imperatives of legal integrity and social justice. As we embark on this collective endeavor, let us remain steadfast in our commitment to harnessing the power of AI for the greater good of society. Let us strive to uphold the principles of fairness, equity, and justice as we navigate through the complexities of the digital age. Together, let us forge a future where AI and legal innovation converge to create a world that is more just, inclusive, and human. In closing, I extend my deepest gratitude to the organizers, participants, and sponsors who have contributed to the success of this conference. May our deliberation be fruitful, our collaboration enduring, and our commitment unwavering. Thank you. Assalamualaikum warahmatullahi wabarakatuh. I'll get back to the MC.
Okay, thank you very much, Professor Supriyono, for the remarkable speech. Now, the fifth agenda is speech from Mrs. Wardah Yusfin, Doctor of Philosophy, as Vice Dean Faculty of Law, Universitas Muhammadiyah Surakarta. For Mrs. Wardah Yusfin, time is yours.
Okay, thank you very much for the time. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Alhamdulillah. Thank you for the time given to me. For this morning, I would like to send my regard to all the participants. Yeah. And ladies and gentlemen, first of all, I would like to welcome all the participants into International Conference on Restructuring and Transforming Law. And on this year's, yeah, we have a very futuristic theme. It is about AI, artificial intelligence, and also because it is related to law faculty, we try to configure AI and legal innovation in the tech revolution. Yeah, we will look into the right, regulation, and also responsibilities. As the Vice Dean of Faculty of Law, I will send my distinct honor and privilege to all the esteemed guests, distinguished speaker, which is they are very expert in their field, scholars, legal practitioner, and all the participants who gathered today in the various corners of the world. The convergence of the legal minds at this conference mark a significant moment in our collective. The journey toward understanding and adopting the profound transformation of law, in this digital age is very, challenging. With the rapid advancement of artificial intelligence or AI and technological innovation, the legal landscape is undergoing unprecedented shift, presenting both opportunity and also the challenge. They demand our attention and also demand our collaboration and innovation to face this challenge together. The theme of this conference underscores the critical intersection between technology and law, because we can, in every part of our life, it is always intersection with the law, highlighting in the imperative to navigate the complex terrains of AI-driven legal innovation, with the keen focus on the right regulation and also what come up from that responsibilities. As we stand on the cusp of a new era defined by automation, machine learning, data analytics, it is incumbent upon us to explore how these transformative technologies can be harnessed to enhance our access to justice, promote transparency, and also uphold the rule of law. It is very important for us to notice that. Throughout the course of the conference, we will delve into multi-phase discussion encompassing the legal, ethical, and societal implication of AI integration in various facets of the legal profession. So we invite all the legal profession to join our conference. From the development of AI, powered legal tools and predictive analytics to the implication for privacy, cybersecurity, and also human rights, our deliberation will span a wide spectrum of topics. So it is a wide topic that will be discussed in this conference. I extend my heartfelt gratitude to our distinguished speaker, whose expertise and insight will illuminate our discussion and inspire new avenue of thought. I also commend the dedication and hard work of the organizing committee, whose effort has been instrumental in shaping this conference into a platform of scholarly exchange and intellectual engagement. To all the participants that attend this conference, I encourage you to actively engage, challenge conventional wisdom, and contribute your unique perspective into these discourses. Your collective wisdom and scholarly contribution will undoubtedly enrich our understanding of the complex interplay between technology and law, paving the way for innovative solution and uphold justice, fairness, and also public interest. As we embark on this intellectual journey together, let us remain guided by a principle of integrity, inclusivity, and excellence. May this conference serve as a catalyst for transformative change, empowering us to harness the potential of AI and legal innovation in advancing the cause of justice and human flourishing in this digital age. Once again, ladies and gentlemen, I extend a warm welcome to you all and wish you fruitful and enrichful experience at the International Conference on Restructuring and Transforming Law. Thank you very much. The time I'll give it up to the moderator or MC. Thank you.
Okay, thank you, Mrs. Warda Yustin, for your wonderful speech. Now, ladies and gentlemen, we will begin the discussions International Conference Restructuring and Transforming Law 2024. This session will be moderated by Mrs. Hanifa Febriani, Law Legal Master, as the lecturer from Faculty of Law Universitas Muhammadiyah Surakarta. And for our moderator, Mrs. Hanifa Febriani, now the time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Okay, good morning, participants of the ICRT conference. The Honorable Chairman, Faculty of Law, Universitas Muhammadiyah Surakarta, the Honorable Distinguished Speaker for this international conference, and the Honorable Speakers and participants of ICRT, hosted by Universitas Muhammadiyah Surakarta. Before we are starting this event, we would like to praise and thanks to Allah Subhanahu wa Ta'ala who has given help to us and the opportunity to attend this international conference. And also let's giving salawat and salam to Prophet Muhammad Sallallahu Alaihi Wasallam. Ladies and gentlemen, today we are going to have a fruitful discussion regarding to the AI and legal innovation in a tech revolution, rights, regulation, and responsibility. There will be distinguished speakers sitting among us. First is Professor Trisa Rajput from School of Business, Economic, and Law at University of Gothenburg. She will deeply explain about AI and the future of business law. And the second of all, we are going to have a discussion with Professor Benjamin Min Hao Chen from University of Hong Kong. He will explain more about AI, especially in the court proceeding. And later, the third speaker will deliver about AI in adaptability of law and public policy. This theme will be delivered by Professor Aidul Fitrisiada Azari from Universitas Muhammadiyah Surakarta. At the end of the seminar, we are going to have a presentation from Prof. Jenny Patterson from Melbourne Law School, University of Melbourne. She will delve deeper into understanding the challenges associated with the regulation. As we mentioned earlier, that the first speaker will be Prof. Trisa Rajput from University of Gothenburg. But prior to this, let me introduce her brief background and her expertise. So, Trisha Rajput is a researcher at the Department of Law, and she is now a lecturer at the Pedagogical Development and Interactive Learning Unit in University of Gothenburg. She was awarded PhD in 2012 with distinction in International Trade Law and Master of Laws in European and International Business Law in 2006 with merit from University of Leeds, UK. She is also a qualified advocate in India. And her research mostly about trade and transport, informatics, and public international law, but currently she also has published some researches in terms of trade and AI, legal consideration for digital infrastructure that facilitate trade and transport, economic sanction, export control, so on and so forth. And her research and her recent publication is the forthcoming one, entitled as States Agency over Algorithmic Decision Making, the Role of Regulators to Protect Human Rights, will be published in this 2024 together. She wrote it with Basubal. And previously, she also wrote about restricting international trade through export control laws, national security in perspective. And I think those kind of writing has proved her expertise in especially about a trade law. Before we are going to start this seminar, I would like to greet Prof. Trisha Rajput. Good morning.
Hello, good morning.
It's nice to see you.
The pleasure is all mine. Lovely to see you too. Thank you so much.
Yeah, we have like almost 200 participants here, and I think it will be a very interesting discussion. And ladies and gentlemen, it will be started by presentation by Trisha Rajput, and later on you can ask to Trisha Rajput right after the presentation. You can use the right hand tools, or you can previously drop your question in the chat column. I think without further ado, you can start your presentation. Thank you.
Thank you so much, Hanifa. I would like to share my presentation, but I guess you have disabled participant screen sharing.
Okay, wait a minute.
Okay, great. Thank you. I think I can now share my screen. All right. Okay, perfect. So very good morning, everybody. I would like to start with a huge thanks to the Faculty of Law, Universitas Muhammadiyah Surakarta, for this kind invitation to speak at the conference today. And I think it's a very topical subject matter. The presentation today, as Hanifa mentioned, is based on a paper that has been authored by me and my colleague from University of Gothenburg, Abhinay Basubal. And for this paper, we have to especially thank Dr. Varda Yuspin, who has been very kind enough to arrange interviews and has acted as interpreter when we were conducting the parts of the interview in Bhasa. And most importantly, her insights, sharing insights about the Indonesian law. So Varda, a huge thanks to you. And we have already visited the law faculty 2 years ago. It feels really good to be part of this project. Yeah, so I'm just going to start right away, dive into the main topic. Now, digitalization has led to the rise of platforms that use algorithms for decision making. These platforms have become quite formidable as social and economic powerhouses, and they yield private power over their users through rules of internal governance. So the presentation today examines the role of regulators to control the private power of platforms derived from algorithmic decision making. So I will adopt a law and informatics perspective and will present the case of peer-to-peer lending, more popularly known as P2P lending in Indonesia, to focus on artificial intelligence-based algorithmic credit scoring. And my intention is really to highlight the pragmatic approach adopted by the Indonesian regulators and what we can learn from them. And they play an active role in contributing to platforms' internal governance to balance human rights protection and digital innovation. And I think even though I'm not a human rights lawyer, I have also in some ways dwelling in a rather new area and hopefully probably learn more from you. So anyway, P2P, classified as high risk in the EU, may be a matter of public interest as it determines a person's access to financial resources or essential services. And as of now, Indonesia doesn't have a particular AI legislation, but POJK 77/2016, POJK 10/2022, and personal data protection law are quite relevant here. So there is some fragmented approach here available, but a comprehensive AI law legislation is not in place. Now, during the past 10 years, P2P lending platforms have grown exponentially in Indonesia, and these platforms combine the old concept of personal credit with digital technology to allow lenders to directly extend loans to borrowers. The payments are channeled through third-party payment providers or banks. The role of the platform is that of a matchmaker who assesses the risk of transaction based on data insights and algorithms. Now, through these platforms, digital technology permeates the very core of the financial products, services, and operations of organizations and radically changes their nature. P2P lending platforms enable lending by performing credit checks and other risk assessment functions. The platforms do not act as a refutation to the line of credit, as the agreements are made directly between the lenders and the borrowers. In the figure before us, you see that the two parties to a P2P lending transaction, the borrower and the lender, features on the top and bottom respectively. And the digital platform that matches the lender and the borrower sits in the middle. The borrower registers with the digital platform, makes an inquiry or application for loan. The platform carries out a risk assessment based on credit scoring of the borrower, a process that currently uses big data analytics and AI algorithms. And depending on the score, the platform sets an interest rate that is published to potential lenders. So thereupon, the lenders lend to the borrowers, which may be channeled through a third-party payment or banking system. Generally, the platform must obtain a license from a local regulator to operate. The inner workings of the platform may vary based on regulatory structure as well as the system's precepts, and which may include the process to determine lending rates, fees charged, method of credit scoring, and the volume of borrowers information given to the lenders. And I believe that most of you are familiar with the system. Now, this is where it gets interesting, because here we're talking about credit scoring using AI algorithms. And the P2P lending platforms are quite interesting because they're built on two affordances, namely convergence and generativity. And convergence is about bringing together previously separate industries or user experience to create multiple new affordances. So for instance, in P2P lending, convergence has led to joining of previously separate industries. So incumbent financial institutions big technology companies active in the finance space, companies that provide infrastructure or technology, and startups to provide lending services to the unbanked population. Generativity, on the other hand, which is the technology's overall capacity to produce unprompted change driven by large, varied, and uncoordinated audiences. So in particular, P2P lending generativity has led to new ways of credit scoring where ability to pay is replaced by the willingness to repay. And this is the interesting part. Accurate assessment of the risk of default for lending has always been an important subject matter for banks and in financial institutions. So during the last decade, AI-led credit scoring of borrowers has revolutionized such risk assessment, as machine learning algorithms can now detect complicated patterns in the data set by drawing correlations. For example, it's quite early in the morning here in Sweden. It's close to 4 a.m. And jogging is something that many of us do in the morning, right? So jogging data is correlated to the healthy lifestyle of a person, and that inference is used to evaluate risk. So if you're a jogger, means you're disciplined, and you probably have a much stable individual preference as compared to somebody else. So this is in the P2P lending context. AI algorithms use registration data of borrowers and their social media activities to generate a credit score, which is beyond the traditional notion of ability of the borrower to repay. The AI algorithms focus on the willingness to repay, that is largely experience-based perspective to risk, as opposed to traditional ability to repay, that is more transactional in nature and represents an ideology-based perspective to risk. So willingness to repay based algorithmic decisions take advantage of data-driven ideation by using personal details, search behaviors, choices, communications, social media posts, GPS locations, usage patterns, insights into social networks to allow P2P lending platforms to hedge risks in innovative ways. And I guess you all are familiar with this because this has been very much in print also in Indonesia. So evaluating risk requires collection of personal information and reconstructing a borrower's profile. In a sense, willingness to repay relies on profiling, which entails finding about individuals' preferences and then predicting their behavior, which becomes the basis for making decisions regarding them. Now, earlier it was quite difficult to gather such behavioral information of borrowers because we all were very personal, and we were not hooked to technology, right? But with the widespread use of smartphones and social media, such granular collection of data, analysis, monitoring of data is easily achievable. Thus, willingness to repay is a derivative innovation emanating from the generative use of big data. So in short, AI-led credit scoring of borrowers has revolutionized risk assessment in favor of lenders. And due to the availability of huge data sets and accessible data source, the effects of the revolutionized risk assessment were confirmed in practice during the conversation that we had with 3 P2P lending platforms in Indonesia. And it's quite interesting, in fact quite shocking, that they revealed that the loan recovery rate is 98% to 100% of the dispensed loans. And of course the sample size is very small, but it was still intriguing to know that it's 98 to 100%. Now, of course, we must take this with a pinch of salt, but such a high recovery rate when compared to traditional bank loans could be possibly attributed to efficient recovery mechanism on the ground, perhaps, or accurate AI-based credit scoring, or both. The credit scoring module of peer-to-peer lending platforms is actually externally sourced as software or service. And a modular approach is adopted as the algorithms are under constant development. The algorithms are generally designed to follow a user-centric approach that relies on feedback. The algorithms are trialed, released, and modified in parallel as the P2P lending platforms operate in a market where one size does not fit all. Therefore, the emphasis on instant release without any careful scrutiny of the algorithmic harm. And the algorithms are constantly learning from our preferences, from user preference and habits, and this aims to maximize the KPIs of platforms, such as conversion rate, number of active users, so on and so forth. Now, the technological architecture of some of the P2P lending platforms allows credit and lending to be bundled together to tap into the needs of the borrowers for every purchase. And in such cases, credit scoring goes beyond lending. The data-driven approach lays emphasis on reliability, trustworthiness, which leads to redefining of identity, which is what they do and who they are. And so indeed, such an approach is reliable and trustworthy for the lenders. However, it is not clear whether these algorithms could be perceived as reliable and trustworthy for borrowers, and that's where the catch is. And this was also quite interesting. When preparing for the paper, we started to really look into the nitty-gritties of things, and also the literature, and what we came across was fascinating indeed. Now, how AI technology for P2P lending in Indonesia is largely sourced. Now, interestingly, the invisible hand behind the P2P lending boom in Indonesia is largely led by Chinese investors. These investors were forced to look for greener pastures ensuing the complete shutdown of P2P lending in China. After swarming to Indonesia, the investors not only invested in expanding the technical capabilities and outreach of the platforms, but also started to exert influence on the direction of business. In addition, Chinese investors have advanced the adoption of their own AI practice and capabilities in Indonesia. So, for example, the algorithm used for credit scoring would be controlled by an entity in China, and the Indonesian P2P lending platform would share the data collected from users with that entity and entrust it to generate the score. But then, if this is the case, one wonders, where is the regulator in this? And so a reflection on the agency of OJK in protection of human rights. In general, P2P lending platforms are hailed as a success story for digital innovation and financial inclusion in Indonesia. According to the Indonesian Financial Service Authority, which is the OJK, popularly called the OJK, by August 2023, outstanding loans dispersed from 101 registered P2P lending platforms have totaled over $3.4 billion US. And that's huge. However, P2P lending has emerged and has shown to engender numerous societal concerns such as privacy, surveillance, and human rights. The concerns arise because digital innovation fosters changes in organized processes and institutional routines, actually altering how organizations operate. Consequently, digital innovation triggers the deinstitutionalization mechanism, which results in erosion of legitimacy for processes and routines that were originally designed for traditional finance. So currently, Indonesian regulators do not regulate the algorithms per se, which are involved in the credit scoring process in P2P lending. Instead, the regulators have adopted a piecemeal approach to regulate P2P lending and the platforms by exerting regulatory oversight and strictures to safeguard personal data of borrowers, mandate institutional collaboration, and curb related perils such as illegal P2P lending, unethical product marketing, and lack of public awareness. So as you can see on the slide here, the action by the regulatory action has come in phases. And so in terms of categorization, you can take 1.0 and the 2.0 approach, and then finally the data protection law that is in place. Regulation 1.0, I mean, it's surely worth dwelling a little bit on this, because in the initial days of P2P lending in Indonesia, many platforms were accused of employing illegal repayment tactics, such as harassing the borrowers, including the family and friends, sharing information about the debt with all their WhatsApp contacts of the borrowers, posting private information in the form of photos sourced from borrowers' phone gallery, online sexual harassment of the borrowers. And to safeguard personal data of the borrowers and to curb the perils such as illegal P2P lending platforms, unethical product marketing, and lack of public awareness, the Indonesian government quickly swung into action with a set of regulations. The OJK promulgated the regulation POJK 77/2016, technology-based borrowing lending service to protect consumer and national interests, while allowing the growth of P2P lending platforms. The regulation prescribed a registration, trial, operation, licensing path for P2P lending platforms, where such platforms would be required to register with the OJK. And post-registration, the P2P lending platform would undergo 1 year operating period, only after which it could apply a formal business license. The above regulation was followed by another regulation which formalized the regulatory sandbox approach for P2P lending platforms. Interestingly, in October 2018, OJK inaugurated a self-regulating industry association called the Asosiasi Fintech Pendan Bersama Indonesia, AFPI, to oversee the market conduct of P2P lending platforms and to protect lenders against fraud, personal data, misuse, unethical debt collection, and high interest rates. And I think this is a fascinating development. Now 2.0, OJK issued regulations POJK 10/2022, Information Technology Based Co-Funding Service, which amended and revoked POJK 77/2016, with the aim of dealing with the development and legal needs of P2P lending within Indonesia. POJK 10/2022 uses the expression information technology based co-funding to refer to P2P lending platform. Article 1.1 defines the information technology based co-funding as the provision of financial services to bring together lenders and recipients of funds in conducting conventional or Sharia-based funding directly through an electronic system using the internet. The difference between the above definition and the earlier one in POJK 77/2016 is the provision of lending based on Sharia principles. And so while there are several changes related to Sharia law and corporate structure and all of that, that's all too very complex, and I'm not an expert in this area, but I'm just going to focus very much only on the credit regulation. Because that's also the focus of this presentation. I think what is interesting is Article 42. Article 42.1 and 2 of POJK 10/2022, the P2P lending platforms to use electronic systems that they own and manage in carrying out their business activities. So, and Article 19.3 prohibits the platforms to outsource assessment of funding feasibility and IT functions to third parties. However, Article 41 allows the platform to exchange data to improve the quality, which includes AI credit scoring. And Article 42, Clause 2 stipulates that platforms must exchange data based on confidentiality agreements, and Article 40, Clause 4 lays down the specific requirements of such agreements. In addition, pursuant to the Article 40, Clause 4, the data exchange cooperation with third-party credit scoring providers has to be reported to OJK. So, in summary, The regulatory response of the Indonesian government comprises gradual measures, yes, that exemplify the emergence of rights protection. For example, through the creation of an industry association to mitigate risks without hampering the potential for financial innovation and financial inclusion. Because I think this is the important balance to strike here, innovation and inclusion, yes. So in addition, for personal data protection laws and regulations applicable to the P2P lending platforms, they are currently spread across various instruments, and I'm not going to go into those details. But one important one is the Indonesian Parliament adopted the Personal Data Protection Law, PDP, as I'm going to call from now on. It's just easy to refer to it as PDP because personal data protection is quite a mouthful, which became effective on 17th October 2022, and platforms have been given a 2-year transition period to conform with the requirements of the law. And I'm not going to discuss this now. I'm going to discuss this a little bit later on in the presentation. But what we can see here, if we look at the slide, is that this is an incremental progress. Be that as it may, the Indonesian regulatory authorities so far have not demanded visibility into the P2P lending platforms' internal processes where AI is used for credit scoring. So if credit scoring is not duly designed, developed and used, it may lead to serious consequences for people's life, including breach of fundamental human rights and financial exclusion. So which is very much the opposite of which the government seeks to achieve, which is financial inclusion. Now this is a very interesting slide, and this is a little bit of combination of informatics and law here. But the diagram before you, the purpose of showing you this diagram is that this diagram represents the conceptualization of the digital transformation process in the context of P2P lending in Indonesia. It shows that the digital innovation has led to redefining of boundaries, creating ecosystems, which has made the firms adopt new strategic approaches. Now, the digital innovation strategy adopted by ecosystems has led to the building up of organizational forms and capabilities, which further enable digital innovation. The figure also highlights the centrality of data and algorithms as digital objects in digital innovation and digital transformation. And as you can see, the gray circle sits right in the middle of technology and innovation, and the digital object here being data or the algorithm. So it's absolutely fascinating. But to give you a more concrete example, I will refer to Dompet Kilat. And Dompet Kilat, I think most of you know it more than me, provides loan to businesses who are members of a fostered group that has a clear supply chain in the industry through AgriKilat solution. The AgriKilat solution, which is targeted towards farmers, provides non-cash loans into a digital wallet. The loan can be used by the farmers to buy farm inputs such as seeds, fertilizers, and selected suppliers. The non-cash mechanism ensures that the farmers use the funds for buying farm inputs only and not divert any part of it to fulfill other personal needs. Interestingly, many of these farmers and suppliers were previously part of a supply chain where credit arrangements were implemented locally based on personal relationships. Now, Dompet Kilat, through the digital platform, has turned the supply chain into an ecosystem, resulting which the suppliers now focus on their core business of selling products. And the digital platform has made the suppliers incorporate digital innovation strategy to realign their business strategy, which is the shadow, which in the shadow is tied to the willingness to repay credit scoring. And Dompet Kilat, as the platform owner, lays the rules of engagement of participation of farmers and suppliers in the AgriKilat solution ecosystem. So in summary, the Dompet Kilat Kilat example clarifies that digital technology is used as an enabler for digital innovation in an ecosystem of actors. Now, interestingly, the loan recovery rate from AgriKilat loans is almost 100%, which of course makes the suppliers happy and the platform proud. And during the interview with the Chief Financial Officer of Dompet Kilat, the dynamics of digital transformation process through the formation of ecosystem was made abundantly clear. However, what remained unclear was the decision-making process of the algorithm which determines the willingness to repay. And as explained above, this willingness to repay approach has triggered the strategic alignment of actors of the ecosystem and is an important consideration for the high recovery rate and the success of the ecosystem. It was also explained during the interview that the algorithmic module of the platform is outsourced to an external software provider, and therefore they have no further insights on its workings. Generally, these external software providers are small companies that reside outside Indonesia, as most of AI algorithms are developed in US or China. Basically, these algorithms are not Indonesian grown. Therefore, in practical terms, although the digital object is at the core of the digital transformation process, their opacity about algorithmic decision making and the jurisdiction in which the digital object resides. So there's complete lack of clarity of what's happening. Now, the cooperative nature of ecosystems necessitates establishment of private rules based on which actors would interact. And now we are inside the ecosystem, looking at what happens in this innovation ecosystem. And it decides what behaviors are encouraged or discouraged, and choose how to enforce them. So these rules are often referred to as platform governance or ecosystem governance. And the governance establishes standards, rules, and processes that define an ecosystem's formal or informal constitution. And ecosystem orchestrators strive for good governance to signal to complementors and the outside world that it is worthwhile to be associated with the ecosystem. However, it is evident from the example of Dompet Kilat, AgriKilat, that there is no effective form of participation or representation of the suppliers or farmers in determining the rules of governing their community. Thus, the governance framework may very well marginalize the right of the farmers and suppliers to maximize value creation and capture of the platform owner. And now this is the problematic part, because the farmers and suppliers are basically not represented. So why regulate AI? I've given you a little bit of background. I've showed you what the problematic aspects are and how does this P2P setup actually impact people and touch people's lives really. And so why regulate? The marginalization of certain actors in an ecosystem is perceived as a threat to democracy, and therefore requires a scrutiny of fundamental human rights and how such rights impact the private rules of ecosystem governance. A clear understanding of what assists in solving the imbalance in bargaining power between actors in an ecosystem and foster a reliable and trustworthy P2P lending environment is quite desirable. Now, the rise of the platform owner as the ecosystem orchestrator who exercises private power has posed a disruptive law and policy change to the modern constitutional state. This has led the scholars to question the role that constitutions play in binding private power similar to public authorities. The private power emanating from an ecosystem may be in conflict with the open environment of a democratic state, which flourish through fundamental rights and freedoms. The fundamental rights are inviolable, inalienable, and enforceable rights designed to ensure personal freedom and dignified existence for citizens and to limit unnecessary interventions of public authorities. So example of fundamental rights are the rights to privacy, data protection, expression rights, equality rights, right to effective remedy. These are generally enshrined in national constitutions. And the fundamental rights were originally aimed at protecting individuals against the power of public authorities through vertical application. Now, all of these rights, rather most of these rights that I've mentioned, are also enshrined in the Indonesian constitution through Article 28. Now, however, the rising power of corporations through platforms and ecosystems, private entities have great impact on the fundamental rights of individuals, which now necessitates horizontal application of rights. This assessment of impact of fundamental rights is now a key component of corporate responsibility. So it's not only the power of public authorities, but it is also vis-a-vis corporations. So in Indonesia, the need for AI legislation is compounded because of its dependence on foreign suppliers for AI solution. So while Indonesia has a high rate of AI adoption compared to its neighbors in the ASEAN region, and of course Indonesia is also referred to as digital archipelago, its AI sector faces shortcomings in internet infrastructure, domestic talents, and cybersecurity. So mindful of Indonesia's shortcomings, China, for example, has used government and private sector-led initiatives to bolster educational partnerships, investment in AI startups, and advancements of cybersecurity cooperation. And China is one of the major investors in Indonesia's technology sector, including AI startups. So over the past years, Chinese companies have provided funding to Indonesia's AI startups in the early stages. And this has provided Chinese businesses with ample opportunity to fortify their position in Indonesia's AI scene. Through investment in nascent AI startups, China has advanced adoption of its practices and capabilities in Indonesia. In fact, China views Indonesia as an anchorage for making economic, digital, political inroads in the ASEAN region. And so in light of the above, it would only be reasonable that Indonesia goes beyond the personal data protection law and proactively engages in the development of appropriate AI legislation and establishment of institutions that would support digital transformation in a safe and secure manner. Now, algorithms, just coming back to the PDP point, which I raised in one of the slides earlier on, algorithms are digital objects and they involve social processes, and as their calculations may be based on direct articulation from the programmer or data that they draw their calculation from, or data generated from calculations in previous steps. Thus, the transparency of social processes has been a subject matter of scrutiny. Now, if you look at GDPR, which is the EU's General Data Protection Regulation, the transparency of social processes has been a subject matter of scrutiny. And algorithmic transparency is briefly dealt with under EU's GDPR. So, for example, more specifically, Article 22 provides that an individual shall have the right not to be subject to a decision based solely on automated processing, including profiling. Now, Indonesia also has an equivalent in Article 10 of the PDP law, which states that individuals have the right to object to decision-making actions that are only based on automatic processing, including profiling. Now, this provision entails that express consent of the data subject is necessary where algorithmic decision making using an algorithm is employed. So Article 34 of the PDP law identifies algorithmic decision making as a form of data processing that poses high risk for individuals and thereby mandates the platforms to carry impact assessment. This provision clearly introduces the element of accountability on platforms that utilizes the algorithmic decision making and bestows the right to an explanation on individuals. So explainability is key here, and explainability of an algorithm should be understood as a legal explanation rather than a casual explanation. And of course, there's quite many details on it, and I do not want to bore you with the detail, but what's important is that explainability is not just about dealing with an algorithm posing as a black box problem, but a matter of non-technical governance of the organization. So these could include algorithmic impact assessments, other form of algorithmic justification based on AI principles, and new technical development in trustworthy AI. So during the past few years, both public and private entities that have connections to technology policy have scripted and endorsed various principles for AI, and I think most of these principles are now are well known. And numerous principles, documents for governing AI have been undertaken by technology companies, governments, intergovernmental organizations, multi-stakeholder bodies, and civil society. These undertakings show a high degree of consistency in incorporating all or some of the principles under 9 broad themes. And those 9 broad themes are privacy, accountability, safety and security, transparency and explainability, fairness and non-discrimination, human control of technology, professional responsibility, promotion of human values, and respecting human rights. And there's quite a lot of discussion also available in academic literature on this. Now, currently, Indonesia has a national strategy on artificial intelligence, 2020-2045, but it has no legislative instrument in the offing yet. And the quest for transparency to mitigate harm that may be caused by AI algorithms are currently dealt under consumer credit and data protection laws. However, I want to emphasize that this is not sufficient, as protecting individuals from harm posed by algorithms requires a much more rigorous approach. Of course, it's important to strike the right balance between protection of fundamental human rights and furtherance of digital innovation, and this is a key point that I want to make. The above strategy document focuses mainly on technological development and the expansion of existing government-funded physical and digital infrastructure initiatives. Now, the strategy document that I talked about, it does mention trustworthy AI and lists 6 principles, namely explainability, fairness, accountability, security, privacy, and robustness. However, the document does not go far to explain this or elaborate this or enunciate this. So further elaboration on these principles remains amiss in the strategy document. Interestingly, the use of the term trustworthy AI in the strategy document may be an indication that Indonesia has sought inspiration from the EU legislative approach in this regard, or is beginning at least to look at the EU. And Indonesia has looked at the European Union before for inspiration. And I mean, let's take the case of the Personal Data Protection Law, which draws heavily from the GDPR. So I think it's worthwhile to then just very briefly look at the trustworthy AI in the EU, but I promise it's going to be rather quick. So in December 2023, the EU agreed on an AI Act, making it one of the pioneering enactments of trustworthy AI. The Act is to serve as harmonized legal framework on AI to foster development, use and uptake of AI in the internal market, and to protect public interests such as protection of fundamental rights. The Act recognizes that transparency is an important ingredient of trust and clarity, and certainly is essential when relying on the decision-making of AI algorithms. The Act introduces a safety regime built on risk-based approach and sets 4 categories, 2 of which, namely high risk, limited risk, require operators of AI systems to follow specific transparency obligations. I hope you remember the triangle that I showed you with high risk and so on in the beginning of the presentation. And Article 1, Clause 8 defines operator as the provider, the user, the authorized representative, the importer, and the distributor. A scrutiny of the high-risk category listed under Annex 3 reveals that credit scoring algorithms qualify to be under the high-risk category. Now, generally, a P2P lending platform could be perceived as an user, of AI because it has outsourced the development of AI functions to an external software provider. Like I explained to you in the beginning, a P2P lending platform would say, well, we have outsourced this part to an external software provider. However, in the EU context, the Act changes the above perception by defining provider as a person or public authority, agency or body that develops an AI system or has an AI system developed and places that system on the market or puts it into service under its own name or trademark, whether for payment or for free charge. So basically, one cannot get away by simply saying, well, we are the user and not the provider. We are the user because we've outsourced this, but that's not to be, because they've put into service. And this putting into service is defined in the Acts as the supply of an AI system for first use directly to the user or for own use. And user here is defined as any natural, legal, public authority, agency or body using an AI system under its authority. So these definitions considered collectively may make P2P lending platforms to be classified as a provider, regardless of whether it outsources the development of the AI platform algorithms to a supplier or develops them in-house. And I think this is quite powerful. And so under the Act, the provider of a high-risk AI system is required to register its system in an EU-wide database managed by the Commission before putting them into service. The provider has to conduct a self-assessment to show that they comply with the requirements for high-risk AI systems and can use CE marking. Also, the provider is required to create a quality management system. The provider has to comply with a range of requirements related to risk management, data quality, data governance, technical documentation, record keeping, transparency, human oversight, and cybersecurity. So if the provider outsources the development of AI system to a supplier, then it has to follow all the above requirements as a provider. In case the provider outsources development of AI system to a supplier outside the EU, then such supplier would have to appoint an authorized representative in the EU to inter alia ensure the conformity assessment. So establish a post-market monitoring system and take corrective actions if needed. So as you can see, that there is quite robust action in place here. But then, what is happening in Indonesia and what's interesting and what could be possible ways going forward? And I think my colleague and I, we were very, very fascinated with the Indonesian approach. And we thought that the Indonesian approach was rather unique. And it was unique in the context of balancing human rights and digital innovation. And so also, I would like to say that there's also something to learn here from Indonesia. So I would like to first present what is this approach that Indonesia has adopted, despite the fact that there is no comprehensive AI legislation in place. But what is it that we can learn from Indonesia here? So the role of the state in furthering the development of AI is varied across the world. AI is made in the wider sense, using materials from natural resources, fuel, human labor, infrastructure, logistics, histories, and classification. And therefore, AI is shaped by political, cultural, economic, historic forces. And the interplay of these forces have got widespread attention, public attention, or caught the widespread public attention on 7th October 22 for the first time, when the US imposed export controls on advanced computing and semiconductor items to China. The US wanted to impact China's AI industry. Semiconductors is a means to an end. It's essential in this. In response, on 1st August 2023, China imposed export controls on metal exports, which are used in chips, electrical vehicles, and a range of telecom products. And this is continuing. I think every day in the paper, one reads very much about these different type of controls. And so once we look at all these controls, it really exemplifies that AI is of strategic significance. And this is the point that I want to make with this little story about this US and China interlude. And not only it is important from strategic point of view, but it's also, AI is also important from geopolitical leadership perspective in the AI race. And AI race is not just about technology, but it's also about normative values that may sometimes manifest as AI nationalism, which has often argued has the potential to turn into arms race. Although it's not clear what constitutes winning in this race, international human rights law approach for AI governance may assist lawmakers to establish and shape the normative values underlying the technological development. The normative values have to be debated globally and tempered locally to serve the needs of the local ecosystem. And so now I would, and here, and as things stand, what is also interesting that China is a world leader in AI research in terms of number of research publications and so on and so forth. And it has also emerged as a forerunner in regulating AI. And China has also now issued a national statement of AI ethics, which refers to respecting human rights and fundamental interests of humankind. And Indonesia, on the other hand, has no regulation on AI, as I mentioned before. And the national policy on the subject simply states that AI should be suitable for use without threatening the safety and protection of human rights. In terms of P2P lending, that uses AI algorithms. So the P2P lending that uses AI algorithms, China adopts a strict regulatory approach, which led to closing down of all the platforms. And the decision of China may not necessarily be related to AI algorithms used by platforms, but it did bring an AI challenge to the shores of Indonesia. So as already pointed out before, Chinese firms continue to deploy their AI algorithms for expansion of P2P lending in Indonesia. And this fact points to the issue that the divide between AI capable and AI non-capable state is not such a far-fetched scenario, and certainly one that can have important and long-lasting human rights consequences. But the Indonesian lawmakers have shown immense regulatory ingenuity in filling the regulatory gap to fight illegal P2P lending, and in the process took stock of the digital transformation process to carefully position OJK into the P2P lending ecosystems. And this is interesting because by virtue of POJK 77/2016, as the first phase of external regulations, not only laid the rules of engagement for P2P lending platform owners through exogenous generative feedback, but it also initiated OJK to become part of this digital transformation process. So the regulator, instead of taking a top-down approach, becomes one of the actors in the ecosystem. And that's, in our opinion, quite interesting. So the POJK, by virtue of the second phase of external regulations that I've described before in great detail, the 2018 phase, through its regulatory sandbox approach, emphasized co-evolution of the platform along with OJK, where the latter being presented as a regulator who is also a collaborative actor in the ecosystem. Also, the establishment of the industry forum, the AFPI, that I mentioned before, furthers co-evolution for the entire P2P lending sector in Indonesia as a whole, because the platform could come together and set industry standards. So POJK 10/2022 as the second phase of external regulation has cemented the role of POJK as the collaborator in the ecosystem. So instead of being outside, being the watchdog, It is part of the ecosystem. So in 2016, when P2P lending in Indonesia was plagued by illegal practices, POJK did not have the ability to influence the internal governance of the ecosystem. However, in recent times, POJK has the ability to trigger endogenous generative feedback. So it feedbacks because it's part of the ecosystem, it also feedbacks to the ecosystem, which would fine-tune the internal ecosystem governance without the need for an imminent external regulation. So this step-by-step approach adopted by the Indonesian lawmakers since 2016 shows how willingness to exercise authority has been translated into ability to exercise authority by making OJK a close ecosystem collaborator through co-evolution. So the emphasis is on co-evolution. Co-evolution is when two parties share the same destiny, so to say, and they co-evolve as they go along with each other. And this is of great significance because the cost of exercising authority is directly related to enforcement. And this viewpoint somewhat becomes evident, for example, from Tompi Kilat's webpage, which mentions incorporated in AFPI and licensed and supervised by OJK. So this shows that the platforms see OJK not as a regulator, but as a partner with a supervisory role. And I think this partnership is an interesting organic dynamic. So while OJK is now entrenched in the P2P lending ecosystem in Indonesia, enforcement of human rights is not easy. The human rights and private law relationship in Indonesia has been quite complex. And Indonesia, and I'm not an expert in this area and I don't claim to be one, but what I have understood that Indonesia is party to all major human rights law instruments. But the judges are not inclined to consider human rights in deciding private law cases. There is inconsistency in applying the law across cases. So under such circumstances, the discussion on digital constitutionalism becomes relevant. And as we go along, digital constitutionalism is perceived as a constellation of initiatives that have sought to articulate a set of political rights, governance norms, limitations on the exercise of power on the internet. And so now in the European context, digital constitutionalism is viewed within the frame that describes the relationship between platforms, states, and individuals. So if you look at the Policino's framing, they describe this tripartite frame as a digital habeas corpus of substantive and procedural rights, which once identified could be enforced by courts as they're inferred from existing rights protected under digital constitutionalism. Now, Indonesia viewed the P2P lending challenges using this tripartite frame, but decided not to implement the digital habeas corpus in its entirety. It allows the platform to exchange data with third parties that may be situated outside Indonesia to improve quality of the platforms, which includes AI credit scoring. Now, such an approach may be viewed as dilution of digital constitutionalism as described before, because it's difficult to make a foreign algorithm designer submit before Indonesian courts. So it's complex. And in common law jurisdictions, courts have used the writ of habeas corpus to order the custodian of an individual in custody to produce them before the court to make an inquiry concerning their detention. And I think we are all very familiar with the habeas corpus. Now, Indonesia seems to have adopted an approach which follows the proverb, if the mountain won't come to Muhammad, Muhammad must go to the mountain. So following the Indonesian approach, the digital habeas corpus may be interpreted as Muhammad must go to the mountain, that is the regulator as an ecosystem actor, assumes the role of an arbiter in case the platform owner as custodian of human rights and has acted beyond their, when such platforms have acted beyond their authority. So, Indonesia's approach of being inside the ecosystem and assuming the role of arbiter, if need be, resonates with Kranzberg's first law of technology. Technology is neither good nor bad, nor is it neutral, as it mostly depends on context and time. So to exemplify Kranzberg's first law, initially the chemical DDT, I don't know if you're familiar with, but there's a chemical DDT, and it was popular to kill malaria-bearing mosquitoes and boost agriculture productivity. But the scientists exposed that DDT was dangerous to humans and the environment, and its use was banned in many countries. Even despite this revelation, India continued to use DDT for disease prevention, helping to cut the annual death toll from malaria from thousands to mere 1,500. Similarly, given the practicalities of financial inclusion in Indonesia, one may follow Kranzberg's first law and argue that Indonesian legislators and regulators have exercised their agency over algorithmic decision-making with due regards to generativity. And so now I would like to conclude because I've spoken far too long. So could I offer some inspiration here? Or I personally feel that this approach that the Indonesian regulator has adopted is quite inspirational in its own right. But moving forward, now legal scholars have argued that the international human rights law approach offers the requisite organizing framework in the design, development, and application of algorithms that takes into account human rights in order to promote algorithmic accountability. They advocate that this international human rights law approach can provide jurisprudential support on frequently contested terms such as fairness and equality, address asymmetries related to so-called AI nationalism, and hold public and private actors accountable legally. However, the critique towards this international human rights law approach is that it lacks effectiveness and really inability to effect structural change. So the argument here is that while there is room for international human rights law approach in AI governance, it has to be nuanced based on the particularities of digital innovation and practicalities of socioeconomic conditions in Indonesia. But it could be something interesting. The EU has seen the promise in the international human rights law approach and has promulgated the AI Act and has emerged as a clear runner in advancing global discussion on trustworthy AI. The US approach, on the other hand, has not that been of a heavy has been of heavy regulation, rather of self-regulation, market-driven governance. So at this point of time, it is no surprise why the two jurisdictions have taken different approaches. I mean, of course, we all know US hosts the leading companies that are creating this technology, and in some quarters holds the view that regulation stifles innovation. And the EU, mostly being on the receiving end of technology, sees the urgent need to balance innovation and societal safeguard. So in the case of Indonesia, Article 40, Clause 1 of POJK 10/22 clearly shows that government wants to leave ample room for adoption of a stance on the use of AI in decision making. The regulation has allowed for exception for data exchange to enhance the quality of credit scoring for P2P lending. The question before lawmakers of a developing country such as Indonesia, and a country that's growing very fast, is not just about whether they should develop AI-specific regulations that would fill the gap created by digital innovation, or govern AI through a mosaic of policy statement, guidelines, corporate ethics, statement and principle. Rather, the pertinent issue is to find the right balance between innovation and financial inclusion. So what would be the approach? Perhaps the international human rights law approach could assist lawmakers or to define the content of rights, as it would present clarity about thresholds which could trigger obligations that so that in succession would guide designers of AI algorithms, both ex ante and ex post, and the users of the platform to hold the platform owner accountable. So I think one has to praise the pragmatism of the Indonesian regulator, because they have in every possible way in their own efforts tried to balance innovation and of course protection of rights. And so with that, I close my speech. Thank you.
Okay, thank you very much, Prof. Lisa, for the presentation. It is very enlightening. I think I have a lot of notes from your presentation, but some things that I underline so much is how the algorithm decision making can harms our human rights, and how our regulation right now has not sufficient to cover all of this issue. And we can reflect to the AI Act in the UK. Especially, I am very interested when you mention about register their AI and algorithm to the data set of EU. Something that I think it is still far behind. I think we are still far behind, and it is also interesting that you mentioned a lot of things, especially about the complexity in regulating the AI lab, how to balancing between our role as a regulator and to both for the businessman and both for the borrower itself. Thank you very much. It is very interesting. And I will give the forum to the participant here to ask directly to the Trisha. Trisha, is there any question from participant here?
And Hanifa, can I just add to what you said? What you say is very, very interesting. And I think the key point here is that Indonesia should not take a blueprint and implement it. Because Indonesia is another country, has its own unique challenges and unique priorities. And so when I look at the EU, when I presented the EU position, it was just to say that this is the EU position, but in no way suggestive that this should become Indonesia's position. And as explained, that Indonesia has its own uniqueness and may want to develop its own, consider its own peculiarities and characteristics, requirements. Yeah. But
Yeah,
yes, you
we have to relate it with Indonesian context, with Indonesian nature as well.
Yes.
I see. Okay, ladies and gentlemen, do you have any question to Trisha? Okay, there is one person, Rota Ranov. Rota just raised hand. You can ask directly to Trisha. Time is yours.
Well, thank you so much, Ms. Teresa, for your presentation today. I'm very grateful for that. I'm Rota. I'm a student at international student at Universitas Muhammadiyah Surakarta. So lately, you talk about OJK involvement in regulating P2P lending in Indonesia. So you were talking that it is you said that it's very important that OJK is an actor in the ecosystems. So the point is this, because Indonesia is cooperating with foreign companies. Like you mentioned before that China is the main investor in Indonesia in terms of AI startup. So how OJK is addressing this international cooperation in the ecosystem because it is regulating in the context of Indonesia, but what about the relationship with foreign companies or foreign investors?
Yes, that is a very, very good question. And I think that is one aspect that I did not touch on because what OJK can do is within its jurisdiction, but then there is this huge possibility to actually negotiate on the state level and put some protections in place. And I think your question hints on that. And you're quite right. Moving forward, Indonesia perhaps has to take a more proactive position and have some agreements in place with countries from which it imports these algorithms. So, example, China or the US. And I think your question also brings up another complex issue because Indonesia imports both from China and the US. And so it also has to perhaps also consider the terms of import of AI and the protections that it would like to have in place for its citizens. But I think I would like to take you back to the question that perhaps for an Indonesian regulator, it's critical to engage with this idea, which it already has started engaging, is what is the right protection regime that they want? Because you want to have financial inclusion, but at the same time, you want to have rights protection. And that's why I propose this international human rights law approach, because perhaps the time has come to engage more thoroughly about the protections, because then one can take action at home, but by virtue of international agreements, one can also protect the state through these international agreements. So a very good question and a very good point. Very good point. Yes, and I think both need to work hand in hand. Yes. I hope I could satisfy your question.
Yes.
Thank you very much, Rota. Is there any follow-up question for you, maybe?
Yes, of course.
Okay. Rota, do you have any followed-up question, or is it enough?
Yeah, I think that's a good suggestion. Like there should be an international agreement between Indonesia and those states that are investing in Indonesian country. And also, I think it's important to work with authority in those countries.
Absolutely. Absolutely. And I always believe in the idea that the students always inspire, and you mentioned that you're a student, and I think so. Now this is a question for future work. So maybe next time you invite me for another presentation, I'll perhaps look at the more international dimension and the international agreements in place. But it's a very good question. But we start from that premise that maybe we need to flesh out what the rights are at home and take stock of things and develop it and then negotiate internationally. Yes.
Yeah.
Okay, thank you very much, Rota. Another question, please, from participant. Okay, or you can just drop your question in the chat box. I think there is someone raising hand here. Oh, Rota, are you just raising your hand again?
Yeah, it was me.
Okay, yes, you can ask again.
Yeah. I want to ask a deeper question in terms of the relationships between the lenders, borrowers, and the platforms. So here we talked about the works of AI in determining the capabilities or the willingness of the borrowers to repay the loans later. And I think that I want to ask, so who is accountable if there is a dispute or I don't know, a fraud that the robbers did? Because the AI could assess that this person has the capability to repay, but in reality it's not the case because AI was just using, like you said, social media algorithms and some confidential informations about the borrowers, and later the lenders will just realize that this person cannot even repay it. So who is responsible? Should we like the platform is responsible or how to deal with it? And I think it's very important to raise this question because even in other cases like using AI in jurisdiction or using AI in legal practice, we always have to ask who is responsible with those decisions that are taken from AI decisions. Can we have the right to be against those AI decisions? Thank you.
I think, Rota, I would like to respond to your question in a different way. The point is, how is determination made? So what is the basis of risk assessment? The basis of risk assessment here, the lenses willingness to pay. And I think the way that the determination of the way, or rather the way that has been, the way that's orchestrated is problematic. And so going through your private information, that bit is problematic. And so, and that's why it's important to take a rights perspective here, because the rights perspective is quite important, because if the Constitution guarantees you that right, and that is taken away from you, that's problematic. And that's why I argue that it's not the vertical application, but it's also the horizontal application. So so the corporations are also responsible for this, and that's why the argument for horizontal application, because of course we all know that the rights are guaranteed, and they're, I mean, if it's in conflict with the state, you're very well protected. But I also made the point that the platforms are now becoming very, very powerful, and they yield quite a lot of influence. And so when they do so, they also impact these rights. So when they impact these rights, the platforms have to be accountable. Does it make sense? Yes. So there's no easy way to get away from their accountability, saying, well, we are not public authority, we are companies. Because that only would mean that you're only thinking about the application from a vertical perspective. But here, the argument I'm making that it also needs to be horizontal.
Okay, thank you so much. So it means that we always have to have human rights based approach. That's it.
Yes, and a balance, of course. I make that case quite strongly because you could take a very heavy regulator's perspective, but if you take a heavy regulator's perspective, you could stifle innovation. So depending on the context, depending on the priorities, because as we know that Indonesia is a growing country in need of finance. So there has to be a balance, because if you go for a heavy regulator hand, then you would be denying access to finance in some ways. You would be limiting access to finance, and that also becomes problematic. So while you take the rights perspective, it's not a simple, it's a more holistic evaluation of things as opposed to one over the other. I think there are no trade-offs here, but a balance is what I propose for.
Thank you so much for the answer.
Okay, thank you very much, Lisa. We have one more question, and I think this is the last in the chat box. There is a question from Ira. She asked about, I would like to ask about if Sweden has a specific AI regulation.
Well, as you know, the EU has the legislation in place, and there is development in that regard. So it's going to be heavily inspired from the EU framework.
Oh.
That's a regulation that is placed on an EU level. Yes.
Thank you very much, Sweden, using the regulation under the EU. Okay. I think this is the final question for all the participants. Do you have any question to the Trisha? To Trisha, I mean? No? Okay. Okay, everybody, we are sorry that we have a technical issue, but we can continue our discussion now. Okay, Trisha, thank you very much for all your presentation. It is very insightful and very wonderful. And on behalf of the committee, I would like to express our gratitude because you are here. It's an honor for us. This is the end of our first session in this ICRT seminar. Ladies and gentlemen, we humbly ask you to open your camera because we are going to have a photo session. Is it okay, Trisha?
Yes, sure.
Ladies and gentlemen, please open up your camera. We are going to have a photo session, and next we are going to have a discussion with the next presenter. Okay. Okay, dear participant, please open your camera. I will count it down. 3, 2, 1. Okay. Wait. Next one. Okay, 1, 2, 3. Wait. Okay, more. Okay, wait a minute. Okay, thank you very much, dear all participants.
Thank you very much.
For Trisa, I hope that we can meet in other opportunities and other collaborations. See you. Okay. Is my voice clear? Okay. I think we are going to move to the next discussion. Here we have Professor Benjamin M. Chen. Good morning, Indonesian time. Mr. Chen.
Good morning. Good morning.
Okay, ladies and gentlemen, please sit still because we are going to have another interesting discussion with Professor Benjamin Chen. So I will just call you as Professor Chen. Is it okay?
Yeah, Ben is also okay.
Okay. So, ladies and gentlemen, before Miss Prof. Benjamin Chen present his presentation, I would like to give a brief introduction about him. So, Professor Benjamin Min Hao Chen is a lecturer at University of Hong Kong. He had his PhD title from University of California, Berkeley in 2017, and his recent publication, together with his colleagues, entitled as Having Your Day in a Robot Court. It is published in Harvard Journal of Law and Technology in 2023, and I think it will be very related to our discussion today. I think without further ado, I would just give the time and space to Professor Benjamin. You can start your presentation. And after that, we will also directly have a question and answer session. Is it okay?
Yeah, okay, terrific. So let me share my slides because I do have some slides for today. Okay, so the title of today's presentation, let me begin actually by just thanking the organizers for the invitation. It's very kind of you to invite me to speak to this audience. And also thank you to all the participants for coming. Today's talk is entitled Having Your Day in Robot Court, and it's based on a paper, as the host said, that was published in the Harvard Journal of Law and Technology. But in this presentation, I not only want to discuss those results, but I also want to talk about some future work me and other collaborators are embarking on. All right, so this talk is about robot judges in the sense of non-human judicial decision-making procedures that employ artificial intelligence. The ongoing project is joint work with Johann Strömer at Max Planck Institute, Pascal Lackenbach at the University of Zurich, Alexander Stramitz at ETH Zurich, and Kevin Tobias at Georgetown University. Okay, and actually this was a project that started, if any of you are kind of worried about publishing, this was a project that started in 2018, okay, when I was a lecturer at Columbia University and I visited ETH Zurich. Okay, so to some of you who have not closely followed developments in legal technology, our paper might seem a bit like science fiction. To some extent it is, okay, but it's actually less fanciful than you might think. And you don't have to take my word for it. Okay, so in 2017, a college president and theoretical physicist asked Chief Justice Roberts of the US Supreme Court whether we'll see AI make judicial decisions. Okay, and this is what the Chief Justice said. The Chief Justice said, it's a day that's here. Okay, and so indeed, we see AI function as decision aids in sentencing decisions, in bail decisions. For example, in the United States, AI is used to produce input that goes into a sentencing recommendation that may or may not be adopted by the court. Okay, there are also examples of AI acting as primary decision makers, right, in decisions about welfare benefits, about air travel exclusion. Certain companies like Alibaba and eBay, they conduct dispute resolution using algorithms. They're algorithms that decide these disputes. Estonia has introduced a small claim AI court. Well, at least they're trying. Okay, so the last report is they're trying to use AI to resolve small claims. In China, there are cyber courts, and China has also introduced this same type case reference system, right, which asks judges who deviate from an algorithmic prediction to justify why they're deviating from that prediction. Okay, so these developments lead to the question, right? Should machines be judges? Okay, and when we ask that question, there might be legal doctrinal concerns, right? Concerns relating to the law as it currently stands. Would a robot judge undermine the right to a fair trial? Would it violate EU regulation related to AI? Would it violate fair trial standards of the European Convention on Human Rights? And these are valid questions, but these are not the questions we are going to be asking here. Okay, so the questions we're asking here are legal ethical questions, right? Even though they're different from legal doctrinal questions, they do have relevance, they do have a bearing on how the law should evolve and how the law should be reformed. So the questions we're asking here are the following, right? Assuming doctrinal challenges can be met, right? Or even not assuming that, right? Are robot judges perceived as being procedurally fair, right? Specifically, do defendants feel like they're being fairly heard? Are decisions by robot judges perceived as legitimate? Now, let me give some background into this research tradition. Okay, so there's a long tradition in legal psychology that studies procedural fairness in this way. Goes back to Lin and Tyler. One reason for studying this perceived legitimacy, right, as opposed to normative legitimacy, is there's evidence that there's higher compliance if the law is perceived as fair. All right, so if people think that the law is fair, they see it as fair, they're more likely to comply. Another reason for asking these questions is that we might care about lay people's judgments of fairness per se. Okay, and the reason why we might care about what ordinary people think about fairness is because these people are subjects to adjudication, right? They're subjects of the law. And if they don't find the process fair or legitimate, this might count as a separate procedural harm. Okay, so we're going to ask the question, right, do lay people consider proceedings in front of an AI judge more or less fair than proceedings in front of a human judge? And going to this project, we had a couple of hypotheses, right? We hypothesized that AI judges are going to be perceived as less fair than human judges. We also kind of assumed, right, hypothesized that this fairness gap would be wider or narrower depending on the context. One hypothesis we had was that human judges are going to be more important if the stakes are high, right? They're going to be regarded as more critical to the process if stakes are high, or when adjudication turns on some subjective determination, right, such as mental state, rather than on the determination of objective facts. Okay, and this means, at least this is the hypothesis, right? This means that AI judges might be accepted by lay people if the stakes are low, and a case turns on objective facts, right? Another hypothesis we had was that human judges have distinct advantages if procedures involve a hearing. Okay, and this is because there is evidence that lay people perceive a procedure with hearing as fairer, and they might consider a hearing in front of a machine as meaningless, right? So in front of a human judge, if they have a hearing, they might feel, okay, I'm being heard, I have a chance to influence the outcome of the case. Whereas in front of a machine, right, they may not feel like they have the same opportunity to express themselves, to have so-called their day in court. Okay, hence the title of this project. And so it would follow from this hypothesis that AI decisions will be perceived as comparatively fairer if there were no hearing, right? That is one of the implications of our hypotheses. And finally, we hypothesized that human judges have distinct advantages if the decision-making process is opaque or uninterpretable. All right. The idea here is that lay people value an interpretable decision-making process, right? They value the fact, right, that they can somehow understand why the decision was made. When such a decision is made by a human, right, and the decision is uninterpretable, we're still somewhat willing to accept that, right? We're somewhat willing to accept that because we're used to that, right? And we feel like, okay, the judge has heard me, right? The judge disagrees with me. It must be for the reasons given by the other side. Okay, but we may not accept the same kind of uninterpretable decisions from machines. Okay, and so it would seem to follow that if AI decisions are perceived as comparatively fairer, it would seem to follow that AI decisions will be perceived as comparatively fairer if the decision-making process is highly interpretable, right? So if the process is interpretable, right, humans will not get that much of a boost, but machines will. Okay, so these were some of the ideas we're working with going into this project. And what I'm going to present right now are the results that were published earlier last year, right? And towards the end of the talk, I'll talk about some of our more recent work, okay? So this is the study run by Kevin Tobias, Alex Dramizet, Kevin Tobias, and I, right? We, at that time, provided some of the first evidence of ordinary people's evaluation of AI judges. Since then, there have been many studies. This was a project that started, as I said, at the beginning of 2018. Okay, and we ran 2 experiments, right, on a sample of about 6,000 adults from the United States. You know, the reason why we chose the United States, in case some of you are interested, is because there are very good platforms for running online surveys there. Okay, so of course we are very interested in running the same study in other countries. By many other countries there isn't that same infrastructure that allows you to access such a big sample at a relatively low cost. All right, so this is what we did, and we had a vignette experiment. The idea of a vignette experiment is to show people descriptions of a particular case. All right, so that is the vignette, right? The description of the case is a vignette. And it's an experiment because we change certain small details about the case, right? So randomly, we change some small details of the case, and we see how people's judgments change, right? When we change those little details of the case. Okay, so for those of you who are lawyers who don't do social science experiments, right? This is the basic idea behind a vignette experiment. I'm happy to explain or discuss more if anyone is interested. Okay, so in this experiment, we vary several things. We vary the decision maker, a human judge or an AI judge. Some people hear that it's a human judge, they read as a human judge. Some people read as an AI judge. We vary the scenario, right? Is it a scenario involving bail, right? Which, in some sense is medium stakes. Is it a sentencing scenario, criminal sentencing, which is high stakes, or just commercial arbitration, right? It's just about money, which is relatively low stakes. We also vary whether there's a hearing, right? Whether there's a chance for the party in the case to make some representations to the legal decision maker, and whether the judge's decision is interpretable, right? And when I say interpretable, there are two senses of the words of the word in which I'm referring to, right? And this kind of aligns with the literature and computer science. Okay, so when I say interpretable, I mean number one, right, that someone can reproduce the decision outcome. Right, so for example, you can have a decision tree and you follow the tree, you'll be able to reproduce the decision of the judge. The second sense of interpretable is that you kind of know which inputs you have to change to get a different output. Right, so for example, you may have lost your case, but you know, based on, the decision-making procedure, right, the decision-making kind of desiderata, if you will, that if you change this particular input, if this thing about your case was different, then you would get a different output. Okay, so this is what I mean by interpretable here. And before I bore you with the details that you may not be interested in, let me give you a preview of the results, right? These are the bottom line, these are the headline findings, right? There is a perceived human AI fairness gap. Right, proceedings with human judges are seen as fairer across the board. This is a result that we get in all scenarios that other researchers after us have also reproduced, and we have once again reproduced this year in a pilot study. Okay, so there is definitely I'm very confident about this. There is definitely a human AI fairness gap. Okay, but we do uncover a way to reduce the fairness gap, which we call kind of offsetting, algorithmic offsetting. And the idea behind that is, AIs are perceived as being less fair than humans, but if there are certain procedures we can build into the AI kind of judicial process, then we can increase the perceived fairness of AI-led processes, such as the same as human-led processes, almost the same, right? Statistically indistinguishable. And such elements include hearings, right? So it turns out that actually giving people an opportunity to speak, even when it's an algorithm that's making the decision, does seem to enhance perceived fairness and interpretability, right? So when AI makes a decision, that decision is interpretable, right? In the senses I've explained earlier, right? That also helps kind of offset this human AI fairness gap. Okay, and this is true for both human and AI judges, right? Meaning, if it's a human judge, right, and the decision is interpretable and there's a hearing, that also boosts, that also enhances the perceived fairness of human adjudication, right? But the idea, and I think I'll go into this at the end, the idea is, for humans that can be very high cost, right? But to have AI do this, that can be relatively low cost. Okay. The final kind of finding, and this is what interests me the most personally, right, is that the human AI kind of the human advantage over AI seems to be related to hard factors rather than soft factors, right? And of course, this is still a bit speculative. We cannot prove it. We do some mediation analysis that suggests this is the case, right? But what I mean by hard factors is things like how accurate, right, is the decision maker, right? How comprehensive is the decision-making process, as opposed to soft factors like, does the party feel heard? Does the party feel like he or she has had a chance to express himself? Does the party feel like the judge, the decision maker, really gets the party, right? These factors don't seem that important, okay? And what really seems to explain the human advantage, right? What seems to explain this human AI fairness gap seems to be really about, seems to be factors like accuracy and whether or not, all the facts have been considered. Okay, so these are all the factors in the experiment. And I'll quickly run through the scenario. I don't want to use up too much time because actually I'm really excited to have this discussion with you. And we can come back to this at some point, but let me just show you briefly what the scenario looks like. This is the arbitration scenario. It was over, whether a camera was defective, like whether it was producing discolored photographs, and the stake was just $2,500. Okay, that's just the stake. Pre-trial bail, higher stakes, right? What's at stake here is, whether or not the defendant has to stay in jail between the time he or she is charged and the time of trial. Okay, and here, the kind of legal factors to be considered, we could say, are a little more subjective, right? It's not about whether a camera is defective. right? The decision maker has to assess some likelihood of the defendant fleeing before the trial, of the likelihood of the defendant committing further criminal offenses before the trial. Okay, finally, custodial sentencing. The stakes here are really high. It's 10 years in prison. And this is a case that's based on US law. Okay, so this is about the felony murder rule. Someone's committing a robbery and he or she accidentally kills someone. Okay, so there's no intent as to the killing, but there is an intent to commit the robbery. Okay, and in the United States, you can be charged with felony murder for that, even though you had no intent to kill, because you did have the intent to commit the crime. Okay, and in the course of the crime, you accidentally killed someone. Okay, and the kind of legal factors here are a lot more subjective, right? It's the nature of the crime, the character of the defendant, the history of the defendant, whether the defendant was under great personal stress of the arrest and committing the crime. Right? These are factors that, as I explained earlier, we think might be difficult for AI to grasp, right? And hence people might feel that AI is less fair. Using an AI decision maker is less fair in such a setting. Okay, so these are the three scenarios. In all the scenarios, the decision went against John, right, who is our hypothetical character in all of these scenarios. What are the participants in our survey told about the judges or the AI? Well, they're usually told, they're told the same thing across all three scenarios. Okay, so if the decision is being made by a judge, they're told the judges are very experienced. They're told that the judge has information about the background of John, right, our character, his previous convictions, etc. Okay. When it's an algorithm, the participants in our study are told the algorithm employs advanced statistical and machine learning techniques. It can predict, flight risk, for example, to a high degree of accuracy, right? And also to keep things constant, right? Participants are also told that the algorithm has, information about John's background, his previous convictions, and potential extenuating circumstances. Okay, one little thing I just want to emphasize, right, in case I wasn't clear the last time, people don't read both of these, right? So you get a scenario, and if it's a human, right, then you read this about the human. If it's an AI, you read this about the AI. And the kind of advantage of this design, right, is people are not alerted to the fact that they're comparing human and AI, right? If people are alerted to the fact that they're comparing a human and an AI, other factors might come into how they respond to your survey, right? For example, I'm worried about losing my job to an AI, right? Let me rate the AI as being less fair, right? So sometimes people ask, why don't you just directly ask people, do you prefer a human or AI to hear your case? Well, that's one approach, right? But there are downsides to that approach. This approach just randomizes, okay? So different people read different versions of the same scenario. With these changes I've marked, and then we see how differently they respond, right, to questions about fairness. For example. Okay, in terms of the hearing, how exactly is it presented to the subjects, right, the participants in the survey? Well, if it's a hearing before an algorithm, this is what people read, right? Before an algorithm makes a decision, sometimes there is an arbitration hearing, sometimes there is not, right? So this is the commercial arbitration setting, right? In John's case, there's an arbitration hearing. John has an opportunity to present his case in person. Right, the hearing allows John to explain why the camera was damaged and therefore should be refunded by speaking to a computer that transcribes his speech for consideration by the algorithm. Okay, and through this hearing, the algorithm is able to evaluate John's credibility and emotions. Okay, so this is what we ask subjects to imagine. If it's not an algorithm but a human, a human, an arbitrator, right? They get the same information, right? Except this time, they're told it's an arbitrator. Okay, so you see that the changes are very small. Right, the scenarios are more or less the same, right? But they are small kind of changes, and if you are kind of randomized to one of these conditions, right? You just read the relevant message for that condition. Yes. Is there a question? No. Okay.
I'm sorry. Just continue.
Yeah, no worries, right? So again, let me also point out one other thing, right? So this is a question of design, right? If you're thinking of running such studies yourself, there is a question of whether or not you want to highlight the fact there is no arbitration hearing, right? So this is arbitration scenario, right? Before an AI with hearing. This is arbitration scenario before a human with no hearing, right? And everything's the same, except that in this case, there is no hearing, and we make that explicit. Okay, the reason why we made that explicit, let me just say that again, right, is because if you don't make it explicit, there is a possibility that people will assume there is a hearing. Okay, so we had a discussion about this, and ultimately we decided we'll just tell people there's no hearing. You know, there is the danger that you are kind of emphasizing this fact, and people may think that therefore they should respond to it, right? But I think that risk is less, is not that elevated here. Okay, you know, people generally assume there is some sort of hearing. If there's no hearing, you can say it. And if people think that's not fair, that's only because people expect, right, that normally there would be a hearing. Okay, and finally, you know, what it means for a decision to be interpretable. This is how we implemented it, right? We say, you know, the arbitrator or the judge or the algorithm's reasoning is rigorous and it's also easy to understand, okay? So all factors were considered using a flow chart, right? It will be possible for John or anyone else to figure out how much each factor mattered to the ultimate decision, and it will be possible for someone else to replicate the reasoning, okay, to see how it changes any one of the factors impacts, for example, the sentencing decision. Although if it's arbitration, it should really be refund, okay, the refund decision, right? So this is how interpretability is kind of operationalized in this study, right? If, you know, subjects are randomized to the non-interpretable condition, right, they're told that the reasoning is rigorous, but it's also not easy to understand. Okay, so all the factors were considered, right, but it's really complex. It's not possible to describe to you, right, the party, in simple terms, how the decision was produced. Okay, how the decision maker's decision was produced. All right. And it's the same whether it's an AI or human, okay? So interpretability is kind of operationalized the same way. Okay, so I hope that was not too technical. Right now I get to show you some graphs, which is great. Right, and you see here, there is a human AI fairness gap. Okay, so what's in blue, that's perceived fairness of the human-led process. What's in orange is the perceived fairness of the AI-led process. And across all three scenarios, you see there is this gap. It turns out the stakes don't really matter, right? We don't see the gap widening as we move from the commercial arbitration scenario to the sentencing scenario. In addition, as I kind of told you earlier, right, we do find this consistent effect, right? That when you have a hearing, that tends to improve perceptions of fairness, right? And when a decision is interpretable, that also tends to improve perceptions of fairness, right? So you can see all of that in the plot here. And you know, you might say this looks really small, right? This is one question I always get. Isn't this a really small difference? Yes and no, right? So optically, it does look like a small difference, right? But substantively, you know, this is about, usually it's about a 0.5 difference on a 7-point scale. Okay, and that is pretty large, you know, as far as these kind of studies go, right? When we talk about persuasion studies, right, being able to move people by 0.5 on a 7-point scale, that's actually a pretty big movement. Okay, people are not going to change their opinions by a lot, usually just based on a small kind of fact, okay, a small change in facts. Okay. Finally, you want to look at one thing. This is the regression table we have. I know not all of you are excited to be seeing this, but let me tell you what we can take away from this, right? So when we ran this first study, we also looked at whether or not there was a so-called interaction, right, between using an algorithm and having a hearing, or using an algorithm and having the decision be interpretable. Okay, and the whole idea of running this regression, I won't go into too many details, right? But the whole idea of running this regression is to see, okay, you know, when we have a hearing, right, does it matter more for a human decision maker, right, than for an AI decision maker? And when the decision is interpretable, does it matter more for an AI decision maker than for a human decision maker? Okay, and if you look at these two rows that I'm pointing out now, it seems like hearing matters more for a human decision maker, and it seems like interpretability matters more for an AI decision maker. But there are no stars here, which means we cannot be confident about these estimates. Okay, so we ran a second study, and the point of the second study was really to try to get enough of a sample size so that we can say for sure, you know, whether or not there is this so-called interaction. Okay. And basically we did some simulations. We decided we're going to need a sample of 5,000 people, and we're going to put all these 5,000 people, all these 5,000 people, they're going to do the same scenario. Okay, so previously we had people spread across 3 scenarios. Right here, all 5,000 people were given one scenario with the same kind of design. Okay, and again, we get very similar results. Okay, so again, there is a human AI fairness gap, right? And we see, for example, here, right, that having a hearing does increase perceived fairness of a human-led process. It does increase perceived fairness of an algorithm-led process. And we also find this, right, that when it comes to when the decision is interpretable, right, that improves the perceived fairness of both the human and the algorithm-led process. Okay. And we find no evidence of interaction. This time we're quite sure. We ran a large study, right? And we found it was, whether the decision maker is an AI or a human, that doesn't really impact, the effect of a hearing or an interpretable decision on perceived fairness. Okay. All right. So what drives the fairness gap? Okay, and there are 2 hypotheses, right? There are 2, well, I wouldn't say hypotheses. There are 2 kinds of factors, right, that might explain this. One is hard factors, as I said earlier, right? The perceived accuracy of the decision maker, the perceived thoroughness and comprehensiveness of the decision, and then there are soft factors, right? So the perceived understanding of the defendant's position, right? Does the defendant feel understood? Does the defendant feel like he or she had a voice in the process, right? So which one of these factors, or maybe both set of factors, right, explains the human AI fairness gap? I think this is an important question. Let me just preface that. I think it's an important question because if it relates to soft factors, that's not something that can change in the near future. Right? Machines are always going to be machines, and what drives the human AI fairness gap is this idea that okay, I want to feel in the defendant, for the process to be fair, the defendant has to feel like he or she has a voice in the process, that the decision making really understands. Then in the short run, this even in the medium or even long run, right, this human AI fairness gap is going to persist, right? But if it's really just about accuracy, about thoroughness, about comprehensiveness, then as AI improves, right, we can expect this human AI fairness gap to basically narrow or even be eliminated. Okay, so this is an important question, and to be honest, to my surprise, I found that the hard factors, right, seem to explain most of the gap. Okay, and I won't go into the technical details here with the statistics, right? But what we did in the survey, we also asked participants, right, whether they thought, for example, defendant had a voice in the process, right? We also asked our participants to say, to what extent do you think the decision maker is accurate in making these kinds of decisions, right? And when they respond to those questions, we have data. And using that data, we can try to do what's called a mediation analysis. Okay, and what a mediation analysis does, it doesn't have the same rigor as an experiment, right? But what it tries to do is tries to say, okay, insofar as there are changes, right, in perceived fairness, to what extent is that explained by changes in these in responses to these questions about accuracy, questions about thoroughness, etc. Okay, and these are some estimates. For example, much of the fairness gap seems to be explained by accuracy, almost 30%, right? And thoroughness and comprehensiveness, that seems to explain another 30%, right? And only about 12% of this fairness gap seems to be explained by understanding the defendant's position, and only 2% is explained by this feeling that the defendant had a voice. Okay, so the human AI fairness gap seems to be driven by hard rather than soft factors, which is interesting. Okay, so overall, what are the implications? Human AI fairness gap is a challenge for robot judges. We said this in the article, and recently, actually, it was repeated by Chief Justice Roberts in the annual report of the U.S. courts. Okay, he actually cited this human AI fairness gap as one of the challenges for using AI in adjudication. We also find, a more subtle finding is that perceived fairness is influenced by hearing, is influenced by interpretability, and that matters both for humans and AIs. Okay, so whether it's a human-led process or an AI-led process, having a hearing and having an interpretable decision does increase perceived fairness. And lay people, it seems, are amenable to some kind of offsetting, right? Algorithmic offsetting. And by that, I just mean, instead of a human process, right? If you're going to have an AI process, you can try to make the AI process, seem as fair as a human process by including certain procedural elements like a hearing and an interpretable decision. Okay, and of course, you might say, well, why can't the humans do that? Yes, right, but the truth is a lot of times with the caseload that confronts courts, for example, in the United States, for bail decisions, right, most defendants in such a proceeding don't get more than a minute in front of a judge, right, just because of the resource constraints, right? So if we are going to use an AI process, right, presumably it's easier to scale, right, and you can include these procedural elements that you cannot include in a human-led process, and that could potentially kind of offset this human AI fairness gap. Okay. All right, I'll come back to any of this, to all of this, if any of you are interested, but I've covered all of this. Now I want to talk about a subsequent paper, right? So what I just presented was a paper that was done, that was started, like I said, in 2018, finally published last year, and this was joint work with Alexander Stravizer at ETH, Kevin Tobias now at Georgetown, and I. After our paper was published, actually, we also saw this paper by Hermschuh and Lachenbach. And what they did there was they considered hybrids. Okay, so not just having a human decision maker or an AI decision maker, but also a human decision maker that's kind of assisted by AI. Right, and this is the key plot from Hermschuh and Lachenbach's article in Psychology, Public Policy, and Law. Right, you find once again that the human AI fairness gap. Okay, if you look at the first line here, right, the dot with the line is a confidence interval. Right, the dot is the estimate. Right, if you look at this and you look at this, you can see, there's no intersection, right? There's a clear human AI fairness gap. Right, humans are just perceived as being procedurally more fair than machines. But the interesting thing is when you have human involvement, right? When you have a human reviewing, for example, machine decisions, then the perceived fairness of such a procedure can sometimes be even higher, right, than an entirely kind of human-led process. Okay, so for example, high kind of probability that a machine decision will be reviewed by a human, that leads people to rate this process as even fairer than just a human process. Okay, so this is very interesting, right? If you use AI alone, right, people see that as being less fair. But if you use AI with a high degree, a high probability of human supervision, right, people see that as being fairer than just a human-led process alone. Okay, so this is the key kind of finding reported in Hermschuh and Lachenbach. And we had a discussion about this, right? And now I want to tell you a little bit more about ongoing project, which hopefully will be interesting to some of you, right? So when I was shown this paper, I said, this is just about the probability of review, right? So you can think about it in economic terms as being the so-called extensive margin, right? What is the probability, of a machine decision being reviewed? And the higher it is, right, the more people feel comfortable, the more people think, right, that the process is procedurally fair. But it says nothing about the intensity of the review, right? What in economics you might call the intensive margin. Right? So this talks about the probability of the review, but it doesn't talk about the intensity of the review. The humans look at a decision and just say, okay, this looks reasonable, let's leave it alone? Or the humans actually, probe further, right? Do they actually look at the underlying evidence again? Right? So these are questions we ask in our ongoing project. Right? We basically ask, instead of varying the probability of human review, why don't we vary the intensity of human review and see what people feel about fairness of such a process? Okay, and I want to show you some of our early results studying such hybrid courts. One thing I want to say here is these are pilot studies, right? So these are preliminary results from pilot study we just ran. The full study is still being conducted right now. I hope to have the results ready for you today, but it's still being run. So we don't have that, right? So you have to take what I say now with a huge grain of salt, okay? The sample size here is small. We cannot be fully confident about these results. Okay, but what we do find is, again, we find this human AI fairness gap. Okay, so I think you can more or less treat this finding as real, as robust, okay? It's been reproduced several times. We reproduced it at least 3 times in our own studies, and I think other studies have also found the same thing now. Okay, so you see this gap between humans and robots. But interestingly, and but perhaps not too surprisingly, right? When you have human review of robot decisions, you see that the perceived fairness goes up. What's a little odd is the level of human involvement doesn't seem to matter, right? So long as there's some degree of human review, some kind of human oversight, then the perceived fairness comes up to about the same. Okay, and so we're still wondering why the intensity of review doesn't matter. We don't know if this is a fluke. We don't know if this will be confirmed in the fuller study that we're running now. But for the time being, it seems like having a human do a thorough review as opposed to a kind of cursory review doesn't seem to help with perceptions of procedural fairness. Doesn't seem to really enhance perceptions of procedural fairness. Implication of this is quite powerful, right? If this is true, it seems like introducing AI into the judicial system has the potential to increase efficiency and accuracy, and potentially there could be some optimal division of labor between algorithms and humans. Okay, so people have this intuitive aversion, it seems, to robot decision makers, right? But it doesn't mean that AI has no role to play in the court system, right? It just means, actually to some extent, if AI plays an assistive role, we can enhance judicial outcomes, right? The outcome of the outcome of judicial decision making by enhancing its perceived fairness and also increasing its accuracy. Okay, so this is all I had for you today. Let me just give you some takeaways, and I'm very excited to hear your questions. All right, so overall, this is a surprising and nuanced story concerning perceptions of robot judges. There is, let me just repeat one last time, there is a human-AI fairness gap, right? But that's not all, right? Even though human judges are generally favored as being more procedurally fair, these advantages don't seem to be inimitable, right? By that, I mean, there is nothing kind of inherent about that advantage, right? It seems to be grounded in hard factors, and this advantage can be eroded over time with improvements in technology. Okay, and based on our current research, hybrid courts that have AI and humans working together, they have a huge potential to increase judicial efficiency and accuracy without sacrificing fairness perceptions. All right, so thank you so much for being here. Thank you for putting up with this, and I'm very happy to answer any questions you have about this project or more general questions about AI in court proceedings.
Okay, thank you very much, Prof. Chen, for the very interesting presentation. And for me personally, I think it's quite new to know that how AI can probably act as a judge. That's totally new for me. Now, dear participant, do you have any question to Prof. Chen? If you haven't had any question, let me ask something to Prof. Chen. Is it okay? Yeah. My question is for us in a civil law country, we are very favored to use a legal reasoning as our basis to deliver a sentence. Is it what is your opinion if the legal reasoning is coming from an AI? Is it fair or not?
Well, those are good questions. All right, so let me maybe come back to reality a bit to answer your question. Right, so in reality now, AI judges are not capable of producing reasoned opinions. All right, so even with ChatGPT, right, it's capable of producing language that makes sense, right? But it's not able to reason from legal first principles to a justifiable outcome. Okay, so far, when we talk about robot judges, right, what we really have in mind are things like traffic tickets, right? Things like bail hearings. And the reason why I mentioned bail hearings is because at least in the United States and also in also many other countries, but especially in the United States, bail hearings are very short because there's no time. The judge is processing a lot of parties. The parties appear before the judge, sometimes for less than a minute. The judge just makes a decision and moves on. right? And in those kinds of settings, you think, well, there's not that much difference between a judge and AI making the decision, right? What the AI needs is the same information that the judge has available to him or her, right? But in terms of the time spent on the case, right, and in terms of what's required at the end, there's not that much difference between a human and an AI, right? Judges in bail hearings don't issue reasoned decisions. They just say yes or no and how much the bail amount is set at, and all of that is done in less than a minute. I can send you the articles about this. Yeah, it is actually very shocking, right? So in that kind of setting, I think that's the most natural setting in which we can think about AI functioning as kind of judicial decision makers. So to come back to your question, in common law countries, I think it's also the same, right? I mean, if this were a criminal law case involving some technical statutory point, there has to be a reasoned decision at the end, right? And that's not the application right now that AI is capable of handling. Yeah, capable. At least I don't think so, right? And based on the experiments I've seen, we're talking about experiments in the sense of not social science experiments, but computer science experiments. I think it's really unlikely that AI will be able to play that role. Yeah. So we can talk. Then fairness becomes even more kind of fantastical, right? Because we don't even know what AI generated opinion will look like. Okay, but I think for now, just looking 5 or 10 years into the future, what's more likely, is AI taking on the role the role of your traffic warden, maybe deciding on traffic offenses, right, based on the evidence, which oftentimes is just a photograph, right, or deciding on bail, a decision that's often made based on the crime that the person is charged with, his or her criminal history, his or her family ties, etc. Like things that can equally be considered by an AI, but if you give it to an AI, to be honest, they're more likely to get consistent results, right, than to many different human judges.
Okay, thank you very much. So, if I'm not mistaken, you say that if it is like a simple case or a small case, it is still very possible to do it with AI, but for the complex one, it is quite problematic, right?
Yeah, it is quite problematic, especially if you have to give a reasoned decision, right? So let me just, philosophically speaking, right, oftentimes when the point of adjudication is not just to get an outcome, right? Oftentimes the point of adjudication is to engage in reasoned debate, right? To have a chance to kind of not only apply the law, but also to, sometimes challenge the law, right? And in those scenarios, at least right now, I don't think, anyone seriously contemplating using AI, right, to resolve those disputes. Right? So if you are talking about practice, I think that's the most sensible application, the most sensible and immediate application of AI is to domains like traffic offenses, bail, right? Decisions that have to be made quickly, right? Decisions that in real life human judges don't spend a lot of time on. Yeah, so I think this is something that has to be emphasized also. Maybe I haven't done it enough in the presentation, right? So a lot of times there's a lot of anxiety about AI judges, right? But the truth is human judges are human, right? And human judges make mistakes, and human judges don't oftentimes they don't spend too much time on one case. I mean, it depends on which court you're in, right? If you're in the Supreme Court, yes, they have a long time to ruminate and to think through all the consequences of a decision. But at many of these lower courts, right, some of them they're just processing hundreds of people a day. And in those kind of settings, right, as much as we can criticize AI, you have to ask yourself, are the humans necessarily better? Or can AI, despite its flaws, actually deliver cheaper, better justice?
Okay. Thank you very much, Prof. Benjamin Chen. Now we are going to answer the question in the chat column from Ira. She said that thank you for your insightful presentation. In her opinion, there is a concern that the justice provided by AI is rigid and does not care whether the justice is in accordance with the principle of humanity or conscience. Her question is, what is your opinion on the implementation of this in your country? And are there any concern and challenges if robot becomes a judge?
Okay, yeah, good question. So let me talk about the case of China. It's a subject I've written about, and it's one of the jurisdictions that's most kind of enthusiastic about incorporating AI into court proceedings. So in China, there have been a lot of projects under the Smart Courts initiative to integrate AI into the judicial system. One thing I should say, for that may not be obvious to many people who don't study China, is that even though there's a national smart courts initiative, right, what the central government does really is just promote the initiative, right? The initiative ultimately is implemented by local courts, and local courts have different tie-ups with different companies to provide AI solutions, right? So there's no national AI solution. There is a national smart courts initiative. Right, but local courts often will sign contracts with AI companies that supply certain technological solutions to them. And I'll say under the Smart Courts initiative, actually, I think at the end of last year, in about November or December 2023, the Supreme People's Court in China actually clarified that ultimately AI cannot render the final decision, right? That the role of AI ultimately can only be assistive. Right, and that's for many other reasons you mentioned, right? There's a worry that AI will make a mistake. There's a worry that ultimately you need to have a human, right, to check that there has been no miscarriage of justice. And so for the foreseeable future, at least in mainland China, I mean, AI is not going to decide, pronounce on questions of guilt. Okay, so that's what's going on right now. In the mainland, I would just say, what AI has been used for. AI has been used to, for example, help judges generate opinion templates. Right, certain kinds of cases come up so regularly, that you can train an AI model to give the judge a template, and that can increase judicial efficiency. They've tried using AI in the courtroom to transcribe proceedings. Right? So I think this is the most obvious application. It's been done in China. Singapore is also doing the same thing. What they also have used AI to do also is to kind of go through evidence, and try to pinpoint the exact point in a, for example, video where someone said something. Okay, so you don't have to watch the whole video to find that portion. You can just search for it using AI. Okay, so these are more mundane applications. They're not applications that go to the ultimate decision making. The most kind of the greatest impingement on human discretion, and I don't use discretion in a bad way here. The greatest impingement of human discretion in the judicial decision making process in China right now is what is this prediction system. Okay, so many courts in China, they have a prediction system where they predict, for example, the sentence that should be given in a particular case, and if judges deviate from the sentence, then they have to explain why. Yeah, but in that sense, it's not that different from the sentencing guidelines. For example, in the United States. In the United States, you have sentencing guidelines, and it does limit the judge's discretion, right? And the judge kind of wants to sentence above or below the guidelines, he or she has this kind of burden to explain why. Okay, so those I've just described some of the developments, but let me come now to the question, right? To the heart of the question, right? And the heart of the question is this: ultimately, I think there's this saying in comparative law, right, which is you cannot compare your theory with someone else's practice, right? It's not the right comparison, and I think the same thing can be said when we talk about human and AI adjudication, right? Oftentimes when we talk about AI adjudication, we are talking about theory, right? We are very harsh on AI. We think that AI cannot kind of fully comprehend a case. It cannot fully grasp the normative core of the case. But we are very lax on human judges, right? And but the truth is, right? So we're comparing the practice of AI with the theory of human adjudication, right? We're comparing the practice of algorithmic adjudication with the theory of human adjudication. But that's not a fair comparison. Right? The fair comparison is between the practice of AI adjudication and the practice of human adjudication. Right? In practice, humans are subject to all kinds of biases. Right? They may be overly influenced by the presentation of the party. Right? Your lawyer will always tell you wear a suit to court, look presentable. Right? Why does this matter? It shouldn't matter, right? But we know it does because judges are humans, right? And they're going to make a judgment about you based on whether you're looking presentable, whether you've shaved, etc. All right, so when we're talking about this, it's true that the use of AI presents many dangers, but also we have to keep in mind, right? Is it really the case that human adjudications are human adjudicators are ideal, right? Is it truly the case that they are fair, in reality, right? That they are able to kind of purge themselves of these prejudices, right? And I think we want to have a discussion, about human versus AI adjudication. I think that's something that really has to be kept in mind.
Okay, thank you very much, Prof. Chen. There is a further question from Mr. Rofi Aulia Rahman. Do you want to give your question directly to Prof. Chen, sir?
I saw the question, yeah. So in the future, should AI replace human judges, or should the judge use AI as his or her assistant? This is the kind of question that, you have to do a lot of research to answer, right? So it turns on a lot of factors, right? So to what extent can AI kind of give accurate decisions, right? As our study suggests, this is one of the most important things, right? So if ultimately people can come to believe and accept that AI does give very accurate judgments, then people may think that an AI process is fair, right? So I think this is to me, I'm not sure about the other researchers, to me, this is the biggest takeaway from our study. The biggest takeaway and the most surprising takeaway from our study, to me, is that the hard factors seem to matter so much and the soft factors not so much. Okay, and so it does seem like, if in the future AI can progress to such a stage where it is actually making very accurate calls based on the data that is being fed, then using AI as a judicial decision maker, that may become more acceptable to people, right? Because they have confidence in the system. Let me just say one thing also, which is a lot of times when people have this aversion to AI, at least it has been shown in the medical setting, right? This aversion is mostly explained by the worry of the exceptional case. And so people are not worried about AI getting things wrong in the routine case. But what people are really worried about is there will be an exceptional case that AI will get wrong. And for that reason, they have this distrust of AI. Right? And I think, to some extent, even though we haven't kind of proven this, I think to some extent this is true also in the legal field. Right? In the legal field, a lot of the worries about AI are not about the routine cases, right? But it's really the worry that there may be this really exceptional case, right, for which a human judge would feel compelled to make or to change the law, right, or to reinterpret the law, or to even criticize the law, right? That an AI wouldn't do, right? An AI wouldn't do that because it's not able to kind of recognize that this case has certain exceptional facts. And so ultimately, I feel, let me just wrap up by saying, I feel ultimately, realistically, we will have a system, a hybrid system, right, where there are routine cases and AI will handle those routine cases. And there's a certain appeal mechanism that is costly, so not everyone appeals, but if you feel your case is special, you can appeal, and then the human will look at it again, right, and consider whether or not there's something truly aberrational, right, something truly exceptional presented by your case, right? And the findings of our most recent study does suggest, right, that such a system would be acceptable to people, that people might even think of such a system as fairer than pure human adjudication.
Okay, thank you very much, Prof. Chen. So here we have a participant just raised hand, Krishna Naibaho. Okay.
No?
I
I saw a hand too.
Yeah. Mr. or Miss, Trisno, do you want to ask question or no? Okay. If you don't, we move to the next participant, Rota Rana for. That's Rota. Okay.
Yeah. Thank you so much for your presentation, Dr. Chen. Thank you so much for presenting this, and I would like to ask if you can provide the title of your paper in the chatbot, or I don't know, you can tell it here so we can read the whole content of your article. And I have something to share, because we know that technology is really starting to innovate many areas, and like this, it is also starting to transform the court proceedings, the court's decisions, and maybe I'm sure it in the future AI will be used for making decision in the courts in the future, or maybe not, maybe yes, we don't know. But if it's the case, I think that it will be very challenging. And don't you think that maybe there will be two options for the person that would be charged by the AI or would be charged by the judge that we use AI, like whether the person should agree to be charged by AI or agree the utilization of AI, or there is no agreement, but the judge directly use AI and the regulation imposed that, but later the person will have the right to be against the judge decision. What do you think about that?
Well, that is an interesting possibility, right? So one way of course is always to give people a choice, and then if they choose the AI process, right, the idea is afterwards they cannot complain, right? But I'm not sure about the second suggestion you made, right, which is that afterwards people can challenge the decision because it's made by an AI, right? And that seems to me that would kind of defeat the purpose, right, of having an AI adjudicator, right? People can go back and reopen a case, because the decision was made by an AI and they agreed to have AI make the decision, right? That seems to me to be a recipe for disaster, right? Because only the people who get favorable outcomes will accept it, right? And people who don't get favorable outcomes, they will challenge the AI's decision, right? And then what you have basically is you have two bites and an apple, right? So it's a good idea, to give people a choice, but when they have the choice, when they've made the choice, it seems like they must be bound by that choice. Of course, this is not to say there cannot be some kind of appellate procedure, right? There can be some kind of appellate procedure, but as I was kind of alluding to this in my previous remarks, right? If there is an appellate procedure, there has to be some kind of a cost, right? So there has to be some kind of a cost because cost functions as a signal. It functions as a signal that I truly believe there's something unusual about my case. I'm not just trying to get a second bite at the apple, right? I am asking you to look at it again, and I'm willing to incur some cost because I believe that once you look at it again, you'll agree with me. Right. So I think this is a terrific suggestion, right? Giving people a choice. And it'll be interesting to see how people choose over time, right? But I think once you've given people that choice, they must be some sense be bound by their choice, right? Which, as to repeat, doesn't rule out the possibility of an appellate procedure, but it cannot be automatic. Right? It cannot be automatic that you can claim that this decision is invalid or ultra vires because it was made by an AI. Right, then you basically have two chances, right? Everybody will choose the AI process, hope for a favorable outcome, and if they don't get a favorable outcome, then they will appeal, right? And this is not good for either of the parties, right? Because if you're a winner, if you win in the AI process, the other party will appeal, right? Just based on the fact that the decision maker was the AI. So you in some sense you cannot have that, right? If we are going to give people a choice, which is a great idea, they have to be bound by their choice. And if there's a appellate procedure, the reasons for appeal cannot just be the fact that the decision maker was an AI. Yeah. I hope I understood your question correctly.
Yeah, thank you.
Oh, that's very interesting. So if the decision is generated by AI, your opinion is the decision should be like a final and binding, and there is no other legal measure to complain the decision. Is it right?
Yeah, what I'm saying is you cannot complain based solely on the fact that it was made by an AI, right? So there has to be other grounds for attacking the decision. Right, because then if it's a bit like arbitration, right? You cannot go to arbitration, get an arbitral award, and then complain that the award was made by an arbitrator, right? That defeats the whole purpose of arbitration, right? So there has to be some grounds, breach of natural justice, right, for undermining the arbitral award. The same thing with AI, right? If we're going to progress into a world where we really have AI adjudicators, and hopefully they are somewhat accurate, right? If there is an appellate procedure, right, where you have a human relook the AI decision, it cannot just be based on the fact that it was made by an AI. right? Because there are always two parties to a case. There's a winner and a loser, right? And the loser can always complain that the decision was made by an AI. That defeats the whole purpose of having the first stage, right? You're much better off just going to the human directly, right? So in some sense, there has to be some filtering, right? And that's why I say there has to be some cost to the pilot procedure, right? So people who have certain facts that they feel are not adequately accounted for in the AI decision-making framework can go to a human. They have to incur some cost to show that they fully believe it, right? And the decision and the reason for attacking the AI judgment cannot just be the fact that it's made by AI. So you get what I'm saying. I'm not saying there's no recourse, right? But there is a recourse, right? But you have to have something better than just saying, oh, it's made by an AI, right? You can say, oh, the law should be changed. The law is outdated, right? The AI hasn't, realized that values in our society have changed. It's trained on old data, right? But our moral, social, cultural values have evolved, and now the law should move in a particular direction. And so it's not so much that it's just made by it's not so much that the decision was made by an AI, but the AI somehow missed something. And I guess to make that kind of argument, you need to know how AI works to some extent.
Okay. My question, can I ask more about it? Okay. Is there any country that has actually implemented AI in the court procedure, or is it just still in a pilot project?
So I guess you're referring to having AIs render judicial decisions. Is that correct? In terms of AI being final kind of primary judicial decision makers, I don't think there's any country that has done that. Estonia said it was going to try to do that for small claims. But I've been reading about it for like 4, 5, 6 years, and I don't seem to be able to find any updates on that project. So maybe that project's dead. But at one point, Estonia was very keen on having it resolve small claims. Other examples, they're not entirely judicial, they're quasi-judicial, right? Administrative. For example, traffic tickets. Right? In China, you can get automated traffic tickets. Right? So it's not a human who's giving you a ticket, it's a camera that's giving you a ticket. Once when I was in Shanghai, I was in a cab and the taxi, and I asked the taxi, okay, the hotel's just there. Actually, you don't have to make the whole turn, you can just turn right here. But he told me there's an illegal turn and there's a camera there and you just automatically give you a ticket. and so there are such systems, right, for these kinds of things. But I'm not sure you call it judicial, right? That is kind of quasi-judicial, administrative, right? But having AI actually pronounce on for example, a criminal case or even a civil case in court, so far I don't know of any examples. Yeah, but I think the most immediate application would be something like bail. Especially in courts that are overcrowded, that just seems to make sense. Or asylum applications to some extent. Although there, the factors, there are even more factors to be considered. Yeah.
Okay, thank you very much. So dear participants, do you still have any question left for Mr. Chen? No, I think that's enough. Before we close our meeting, would you mind to give some concluding remarks from our discussion now?
This is for me, yeah?
Yeah, like a closing statement before we close our discussion. So,
right, okay. So to wrap up, I guess this discussion is very interesting, right? I guess one of the questions that we have is, to what extent this is reality, right? Which is why I started the presentation the way I did, right? This is the direction things are going in. As I said at the beginning, AI, you may not realize it, right? But there are actually a lot of AI tools that are being used in court, right? AIs are not judges yet, right? But they are producing a lot of the materials that judges are consulting, right? For example, the probability of a criminal defendant reoffending, right? In the United States, the Compass algorithm actually provides judges with this prediction, right? And judges, to some extent, rely on that prediction, right? So even though AI is not the ultimate decision maker at this point, right, it is influencing judicial decision making, right? And our discussion today kind of looked at what the world in the future will look like if AI were to assert itself more in court, right? What roles AI could play, and not undermine the perceived fairness of the judicial system. And the basic takeaway from everything I've said today, there is a perceived human AI fairness gap, right? So in the near future, if you're going to implement AI, you have to worry about whether or not citizens will accept, right, AI decisions. But as I said, and this is the most interesting thing, right? It doesn't seem like AI that humans have this, inimitable advantage, right? The advantage that humans have over AI in judicial decision making right now, in terms of procedural fairness, that seems to be based on hard factors like accuracy. And if AI improves, if people can believe that AI is actually rendering correct results in the vast majority of cases, then we might see this fairness gap close, right? So a future in which AIs are adjudicators, that's not really as far away as you might think.
Okay, thank you very much for a very insightful discussion. I think that you have articulated some points about how AI in a court proceeding, how what are the issues if we are going to have AI in our court proceeding, and I think it's a very new and insightful. Thank you very much, Mr. Chen. I think we are reaching the end of our discussion for this session. But before we close it, we would like to ask the speaker and participant to have some picture. Is it okay?
Yes, absolutely. How do we do this?
Okay. Wait. Okay. I would like to ask for the participant to open up your camera. We are going to have a photo session.
Okay. Slide 1. 1, 2, 3. Wait. Slide 2. 1, 2, 3. Slide 3. 1, 2, 3. Slide 4. Slide 5. Slide 6. Okay, done.
Okay, thank you very much for the speaker and for the participant here. It's an honor for us for having me, Mr. Chen. And okay, wait. And I hope that we can have another opportunity to meet offline, especially. And we are waiting for the result of your current publication. So I think that it will be very interesting. Thank you very much, Mr. Chen.
Thank you so much for coming, and thank you so much for having me. All right.
Yeah.
Bye-bye.
Okay, see you.
Hope we see in person soon. Yeah, bye.
That is very interesting study. Okay, ladies and gentlemen, we are going to have another session. But before we are conducting our third speaker, I think we need a break, like about 5 minutes, and we will continue this room with another speaker, Prof. Aidul from Universitas Muhammadiyah Surakarta, and Prof. Jenny from University of Melbourne. So the next session for Prof. Aidul and Prof. JD will be conducted at 11:30. So you can have a break like 10 minutes to have your coffee or your brunch. Thank you very much.
Sebagai usaha untuk merespon dan mengapresiasi perkembangan ilmu hukum yang berkembang pesat, dibutuhkan tenaga-tenaga terdidik yang berkualifikasi dan kompeten guna meningkatkan kualitas sumber daya manusia yang memiliki keunggulan secara terukur dan frontier dalam pengembangan ilmu hukum.
Assalamualaikum warahmatullahi wabarakatuh. Saya Profesor Dr. Kli Wardiono,
Sebagai usaha untuk
Dekan
merespon
Fakultas
dan
Hukum
mengapresiasi
Universitas
perkembangan ilmu hukum
Muhammadiyah
yang berkembang
Surakarta.
pesat, dibutuhkan
Fakultas Hukum
tenaga-tenaga
merupakan
terdidik
salah
yang
satu dari 12
berkualifikasi
fakultas
dan
yang
kompeten
ada
guna
di
meningkatkan
Universitas
kualitas
Muhammadiyah
sumber daya
Surakarta.
manusia yang memiliki
Sebagai bagian
keunggulan
dari
secara
perguruan
terukur dan
tinggi
frontier
Muhammadiyah,
dalam pengembangan
Fakultas
ilmu
Hukum mengemban visi
Assalamualaikum
untuk berbasis nilai-nilai transendental.
melalui aktivitas penelitian disertasi secara mandiri dan mendalam dengan memperhatikan grand design, orisinalitas, dan kualitas penelitian. Tujuan pendidikan program doktoral kami adalah 1. Menghasilkan lulusan yang memiliki kemampuan mengorganisasi penelitian dan pengembangan ilmu hukum secara kritis dan mendalam. 2. Menghasilkan lulusan yang memiliki etika dan moral, serta berpengetahuan luas sebagai frontier di bidang ilmu hukum. 3. Menghasilkan lulusan yang memiliki kemandirian akademik, inovatif, kreatif, dan progresif. Setiap penelitian disertasi diuji dalam ujian terbuka yang dipimpin oleh Ketua Senat atau Rektor beserta Dewan Guru Besar Fakultas Hukum. Program studi Doktor Ilmu Hukum UMS memiliki tim pengajar profesional, para guru besar, dosen tamu bertaraf nasional dan internasional.
Program Doktor Ilmu Hukum Fakultas Hukum Universitas Muhammadiyah Surakarta telah memberlakukan kurikulum yang mutakhir yang didasarkan pada perkembangan ilmu pengetahuan dan teknologi serta standar KKN level 9 dengan berdasarkan pada keberlanjutan proses pembelajaran yang partisipatif, produktif, dan menekankan pada pendekatan keilmuan yang integratif, holistik, kolaboratif, dan aktif. Di samping itu, semua yang dirancang dalam kurikulum adalah dalam rangka pengembangan kemajuan mahasiswa.
Saya Satrio Teguh Pranowo. Dalam hari ini saya akan melaksanakan ujian terbuka untuk memperoleh gelar doktor dengan judul penegakan hukum terhadap kejahatan seksual terhadap anak berbasis transgender di Kabupaten Pacitan.
Mahasiswa program doktor wajib menempuh 42 SKS dan mengikuti perkuliahan secara hibrid atau gabungan tatap muka dan daring secara bersamaan untuk memastikan perkuliahan dapat diakses dari mana saja, serta mempublikasikan hasil penelitiannya pada jurnal nasional dan internasional bereputasi.
Hello everyone, my name is Rota. I'm from Madagascar and I'm a doctoral student at Universitas Muhammadiyah Surakarta now. I have a great experience to tell you today. I was really amazed that I have many classmates that are very collaborative and are really willing to exchange along my study process. This is a very good key for a doctoral student because doctoral study really needs motivations because it's a very long journey. Apart from that, we have a very well-skilled lecturer at Universitas Muhammadiyah Surakarta that are very engaged to help students in their findings, researches, and legal studies. Apart from that, this Department of Law at Universitas Muhammadiyah Surakarta has a prophetic and transcendental basis.
Assalamualaikum warahmatullahi wabarakatuh. أنا آية محمد من مصر. أنا بدرس في جامعة المحمدية سواركارتا. درست هنا قانون، ماجستير في القانون، وحاليا بكمل دكتوراه في القانون. الحمد لله أنا مبسوطة إن أنا في دولة إندونيسيا، لأن العلاقات الدبلوماسية بين مصر وبين إندونيسيا قوية، وهي مثال جيد للعلاقات الدولية الدبلوماسية. ولأن إندونيسيا ومصر دولة إسلامية، فأنا حاسة بالأمان هنا ومبسوطة لوجودي هنا. التعامل بين البروفيسور مع الطلبة الأجانب الحمد لله تعامل جيد جدا، وفي مساعدة مع اختلاف اللغات. لو بنواجه أي صعوبات لاختلاف اللغة بيكون في مساعدة من البروفيسور، وبيكون في مساعدة من الطلبة المتواجدين معنا في الفصل. أنا مبسوطة جدا وأتمنى إن كل زمايلي يكون ليهم فرصة إن هم يجوا دولة إندونيسيا ويزوروها ويتعرفوا على الثقافات المختلفة، وإن هم يلاقوا فرصة جيدة للدراسة في جامعة المحمدية، لأن هي من الجامعات المشهورة جدا هنا، وهي سلسلة كبيرة جدا في إندونيسيا. وشكرا.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera untuk kita semua. Saya Dr. Ridwan, Sarjana Hukum, Magister Hukum, Rektor Universitas Muhammadiyah Demak, sekaligus alumni Program Doktor Ilmu Hukum Universitas Muhammadiyah Surakarta. Ucapan selamat dan sukses atas kemajuan Universitas Muhammadiyah Surakarta secara umum dan Program Doktor Universitas Muhammadiyah Surakarta. Sebagai alumni Program Doktor Universitas Muhammadiyah Surakarta, saya merasa bangga sekali pernah dididik, diberikan pembelajaran yang begitu banyak. Nah, terhadap saya, karena itu saya menyampaikan ucapan terima kasih yang setulus-tulusnya dan setinggi-tingginya.
Kegiatan akademik mahasiswa juga ditunjang oleh pelayanan yang optimal dalam rangka meningkatkan kualitas lulusan berupa pendampingan penulisan jurnal internasional bereputasi serta kegiatan klinik bimbingan disertasi yang mendorong mahasiswa agar lulus tepat waktunya.
Surakarta atau dikenal dengan Solo merupakan kota terbesar kedua yang terletak di Jawa Tengah. Dengan tagline The Spirit of Java, Solo menjadi kota yang sangat ramah dan penuh dengan budaya. Salah satu hal yang menjadi daya tarik masyarakat datang ke kota Solo adalah pendidikan. Didukung sarana pendidikan mulai dari taman kanak-kanak hingga pendidikan tinggi, Solo tetap mengedepankan pendidikan sebagai prioritas yang tidak dapat dikesampingkan. Universitas Muhammadiyah Surakarta sebagai Universitas Muhammadiyah ternama di Indonesia. Terletak di kota Solo, Universitas Muhammadiyah Surakarta telah mengabdikan diri dengan menyumbang sumber daya unggul kepada negara Republik Indonesia. Sejak didirikan pada tahun 1958, saat ini Universitas Muhammadiyah Surakarta berhasil menempati 10 besar jajaran perguruan tinggi terbaik di Indonesia. Hingga kini, Universitas Muhammadiyah Surakarta telah memiliki 12 fakultas dan 60 program studi. Fakultas Ekonomi dan Bisnis, Fakultas Kedokteran, Fakultas Teknik, Fakultas Komunikasi dan Informatika, Fakultas Ilmu Kesehatan, Fakultas Keguruan dan Ilmu Pendidikan, Fakultas Farmasi, Fakultas Psikologi, Fakultas Geografi, Fakultas Agama Islam, Fakultas Kedokteran Gigi, Fakultas Hukum. Selain program studi Sarjana S1, Universitas Muhammadiyah Surakarta juga menyediakan program Pasca Sarjana S2 dan S3. Untuk menunjang pelaksanaan belajar mengajar, Universitas Muhammadiyah Surakarta dilengkapi dengan sarana dan prasarana yang memadai. Universitas Muhammadiyah Surakarta, wacana keilmuan dan keislaman.
UMS adalah pilihan yang tepat bagi saya dalam pengembangan diri dan prestasi. Tidak hanya kegiatan perkuliahan di kelas, sederet kegiatan organisasi kemahasiswaan serta pendampingan yang dilakukan secara intensif menjadi alasan tersendiri bagi saya untuk tidak memilih kampus lain sebagai tempat melanjutkan studi. Universitas Muhammadiyah Surakarta, unggul mencerahkan semesta.
Alhamdulillah, saya sangat bangga menjadi bagian dari Universitas Muhammadiyah Surakarta yang terakreditasi umum.
Good afternoon, Prof. Aidul. I cannot hear your voice. It's still mute, actually. Oh, wait a minute. Prof. Aidul, you're still mute. Okay. We can hear your voice clearly, Prof.
Hello. Can you hear my voice?
Yes, it's very clear.
Okay.
Okay.
I'm so
ladies
sorry
and-
because in here so noises. Okay, please. We can start.
Okay, thank you very much, Prof. Aidul. Ladies and gentlemen, we are going to have our third discussion with Prof. Aidul Fitri Siada Azari. He will deliver his speech about AI in adaptability of law and public policy. But prior to his presentation, I would like to give a brief introduction about Prof. Aidul. So Prof. Aidul is a lecturer, a constitutional law lecturer in Universitas Muhammadiyah Surakarta. He obtained his doctoral degree from Universitas Indonesia, and he was also a chief of Komisi Yudisial in Indonesia.
Commission.
Judicial Commission of Indonesia from 2016 until 2018. And his research focused on constitutional law and also state institution. So without further ado, we would like to give the time and space for Prof. Aidul to explain more about AI and public policy. Time is yours, Prof.
Thank you, Mrs. Hanifah. Assalamualaikum warahmatullahi wabarakatuh and good evening. Good evening. I would like presentation for 20 minutes. I think just only 20 minutes. So it is very fast. And I will presentation about. Can see my PowerPoint?
Yes, it's crystal
Okay.
clear, sir.
My title is AI Artificial Intelligence in Adaptability of Law and Public Policy. And the systematic of my presentation, first introduction. So after that, regulation of an AI in Indonesia and national strategy of AI in Indonesia, 2012 and 2045. First of all, for introduction, AI in general election, we know we use not all the candidates use the AI, but I think we know Prabowo Gibran use the AI generated for the campaign of a presidential election. It is, I think, it's very interesting because in general election, for the first time in Indonesia, the AI was used in the president's candidates, Prabowo Gibran and also Anies and Muhaimin Iskandar and the other candidate is Professor Mahfud MD and Ganjar Pranowo. Not only in presidential election, but in legislative election, the AI generated was used used by the Golongan Karya, and Golongan Karya provides the AI generated about Soeharto, and Soeharto speaks about the importance of development, the importance of national integration, and etc. So this is the phenomena of AI in general election. For information, the AI in Indonesia is very common use in Indonesia. By the data, the most visits of artificial intelligence is globally in 2023, US the first ranking. After India, the second, but Indonesia the third ranks the most visits to artificial intelligence. So this is the huge million. Is not a million in Indonesia, but in English it's million, billion. It is huge visitor from Indonesia. This is so far from England, from Japan, and from Germany. So the most use of AI application in Indonesia, the first is ChatGPT, approximately 50%, and copy .ai, Luminar, Oracle, DALL-E, LIE, and Automatic. This is the most use of AI application in Indonesia. So the AI application is very important and very common use in Indonesia. But the problem, how about the regulation of AI in Indonesia? Unfortunately, Indonesia has no particular legislation regarding AI. No acts, no law about concerning AI in particular. However, the Electronic Information and Transaction Law of 2008, in Article first, Article 1.8 determines electronic agent. So the electronic agent that can be used as a legal basis for AI. The electronic in the article, an electronic agent is a device from an electronic system that is created to carry out an action on certain electronic information automatically, which is organized by a person. The terms automatically can be interpreted as guides for understanding AI as an electronic agent. This is the provision of EIT that provides a legal basis for AI. Electronic agent can be interpreted as EI. The other legislation, the Personal Data Protection Law of 2013 in Article 10, verse 1, determines processing automatically. The term, the process of processing automatically, EI, including profiling, which give rise to legal consequences or has a significant impact on the personal data subject. So, based on the term, based on the phrase of processing automatically, the PDP law is the law that determines that regulates about the AI, but however, not direct term about AI. The legislation of Indonesia use processing automatically to refer AI as the legal object in Indonesia. In the regulation level, President Regulation number 95 of 2018 concerning the electronic-based government system, or Indonesia is SPBE, Sistem Pemerintahan Berbasis Elektronik. In President Regulation, the President Regulation regulate about utilization of AI in decision making in public service. So the AI in the regulation, in this regulation, have been regulated as the part of electronic-based government system. So AI is the part of decision usage in decision making and public service. Okay. The other regulation is a regulation of the Ministry of Communication and Informatics number 3 of 2021 concerning standards for programming business based on artificial intelligence. This is a regulation particularly created for a licensing for the business activity based on AI. So this is particular for business activity, but not only business activity. The business activity must be based on AI. The regulation regulates about a license for business activity based on AI. The other regulation is circular letter of the Ministry of Communication of Informatics number 9 of 2023. This is concerning the ethics of artificial intelligence. It is very interesting because this is in the circular letter, there is an assumption about AI has the ethics, has a moral that can be used for the artificial intelligence in Indonesia to provide a service for a public. So the use of artificial intelligence must be use the ethics. This is very interesting because, of course, artificial intelligence is a machine. It's a machine, but how does the machine has the ethics? But the circular lecture of Ministry of Communication determines ethics about inclusivity, humanity, security, accessibility, transparency, credibility, accountability, personal data protection, sustainable development and environment, and intellectual property. And based on, according to the ethics, the business activity that use artificial intelligence have use the ethics of AI. Okay. The other regulation is Indonesian Financial Service Authority or OJK Indonesia atau in Indonesia in bahasa Otoritas Jasa Keuangan release guidelines for a code of ethics for responsible and trustworthy AI in the financial technology industry. Based on the guidelines, there are several ethics that created based on the OECD or AI Principle and National Institute of Standards and Technology AI Risk Management Frameworks. But very interesting in Indonesia. In Indonesia, because the ethics of AI has been added by the Pancasila, the important ethics, the values that must be used in the AI. So based on the OECD principle, the Indonesian Financial Service Authority provides guidelines for code ethics about Pancasila, beneficial, fair and accountable, transparent and explicable, and robustness and security. This is very interesting because in Indonesia, there is no legislation about AI, but several institutions in Indonesia has have regulation about ethics for AI. Okay, this is the regulation of AI in Indonesia. How about national strategy of AI? Then the national strategy of AI that's created by BPPT, Badan Pengkajian dan Pengembangan Teknologi, or Agency for Assessment and Application of Technology of the Republic of Indonesia. The BPPT create about national strategy of AI for 2020 and 2045 in two agenda. The first agenda, there are 4 areas of focus. The national strategy of AI must be great about ethics and policy. This is the area of focus for AI. And talent development. Of course, infrastructure of data, and industrial research and technology. This is the area of focus. But based on the area of focus, there are 5 priority areas in health services. I think if we use Halodoc or the medical electronic, I think medical. We know about the using of AI in health services. Bureaucratic reform. This is very important because based on the President Regulation number 95 of 2018, the government of Indonesia must be governed by the electronic based government system. So the bureaucratic reform must be done, must be managed based on the development of AI. And the third is education of research. Of course, education of research is very important for the development of AI. I think basically the utilization of AI is very important. Is in very basic in for educational research. And the fourth, the priority areas is food security. Food security. It is the most important challenge in our century, food security, because we know about climate change, we know about scarcity of agricultural areas, and food security is the challenge, the big challenge for us. So the utility of AI very important for food security. And the last is mobility and smart city. I think the pressure of demography in cities, in the main cities, particularly in the big city and metropolitan city, must be use AI to provide mobility, to provide the easy mobility and smart city for the resident of city. So this is the national strategy of AI for Indonesia for 2022 and 20 and 2045. And this is the framework of national strategy for Indonesian artificial intelligence. I don't know how I can explain this this picture, because the picture use bahasa, not English for the information. So in the top vision of Indonesia 2045, and there are 5 priority areas about artificial intelligence, about health services, bureaucratic reformation, educational research, food security, and mobility, and smart city. And after that, there are 4 area focus. So in the bottom, there is a ethic and policy. Ethics and policy that has purpose to implement AI, that has implement AI with the ethics accordance with the values of Pancasila. This is the fundamental of national strategy for Indonesian artificial intelligence. I think so. Enough, Ibu Hanifah Febriani, because I still have 2 minutes. Thank you.
Thank you very much, Prof. Aidul.
It's very fast.
There is a question here.
Hello.
Yeah. Is there any question from participants here?
Any question or enough?
Maybe I have one. It's only brief, Prof.
Only
what do you Yeah, what do you think?
Okay.
There is one
Rota.
Rota.
Okay. Please. One more question.
Yeah.
Yeah. Yeah, thank you so much, Prof. Aidul, for the presentation. Thank you so much. My name is Rota, PhD student, international student from Madagascar. Can you give for a concrete example, because it is talking about the integration of AI in public policy, and can you give because you talk about 5 priorities area like health services, bureaucratics and education or research and food security. So I'm interested in the food security one. How could we use AI in this area related to public policy? All right, of course.
Sanepa can repeat again the question because it's very noisy.
Can you give a concrete example the use of AI in public policy?
Okay. For example, in health security. Health security, you know about Halodoc. This is medical. What is this? This is medical electronic medical. Halodoc. There are several applications about medical electronics. Yeah. So the application of medical electronic, I think, basically must be created by based on the AI for providing health service. Yeah. For example, in mental health, for example, you can use the medical I think this is not endorsement. I use one application, Halodoc. This is the promotion. Halodoc. You can consultation about mental health with some with a doctor or psychiater by using the Halodoc or the application. So the programming, the process of Halodoc, process of consultation, not only not only human interaction, I think the because the application, it is a machine, it is the electronic. There is for not all, but for several parts. Of course, use the AI as the part as the automatically processing. So we can, for example, we consultation about when we can contact the psychiatrist, and the application you automatically answer about the date for application for the consultation. This is I think this is the application of AI, but not only in medical health or health service, in public policy and bureaucracy for information for licensing license. The license must be managed by the electronic license. Perizinan electronic, the license as electronic license. Not, of course, not only. Of course, in electronic license, there are AI as a processing automatically automatically processed for service the license for public. This is, I think, this is the example for AI in public policy. Okay, this is the in license. And I know about the the decision making for justice. In the Europe, I don't know about Indonesia. In the Europe or the other countries, the AI is used for help to judge for making this decision. And how about in education? This is the problematic. For example, for lecture in university, for helping the development matters of a lecture, Mrs. Hanefa, I think you know, we have used the AI to helping the development to helping the development of my lecture course and method of course of university. So based on the data from most the application that use in Indonesia and the most visitor of AI in Indonesia is the very huge visitor of Indonesia. So I think in public policy, it is not it is very common to use the AI. But the problem is not the application. The problem is there is no regulation. There is no particular legislation, and there is no problem of ethics for AI actual utility in our country. Okay. Okay, that's all, Mrs. Hanifa. Because
Okay, I think that you also have another agenda after this, right?
yeah. Because
Okay.
I am still in Universitas Indonesia in Depok. Thank you.
Okay, thank you very much, Prof. Aidul, for the presentation. It is very insightful that Prof. Aidul has mentioned about the use of AI in public law, especially. Very much, Prof. Aidul. See you on the next opportunity.
No? I
Thank you.
cannot hear. I cannot hear.
Thank you very much, Prof.
Yeah. Thank you.
On
Yeah.
the next
And
opportunity.
good evening and Assalamualaikum warahmatullahi wabarakatuh. And I apologize about the limited time for the presentation. Thank you.
Thank you very much.
Assalamualaikum warahmatullahi wabarakatuh. Could you leave from this Zoom?
Yeah, sure. You can leave from this. Okay, ladies and gentlemen, we are going to have our final session or the fourth session. It will be delivered by Prof. Jenny Peterson. But before I introduce the speaker, I would like to greet Prof. Jenny. Good morning, Prof.
Hello, I'm very pleased to be here. Thank you for having me.
Okay, thank you very much, Prof. Jenny Peterson. Ladies and gentlemen, I would like to give a brief introduction about our fourth speaker. Her name is Prof. Jenny Peterson. She is a law professor from University of Melbourne, Australia. Her research is related to she is also the director of the Center for AI and Digital Ethics. Jenny's teaching and research focus on consumer and data protection law and ethics in the context of emerging digital technologies. Some publication by Prof. Jenny, like in the 2024, the current one, she wrote a book chapter, Consumer Protection Law and AI, and in the 2023, in a book chapter, she also wrote about money, power, and AI. So without further ado, Prof. Jenny would like to give her presentation about generative AI in practicing law. Prof. Jenny, the time is yours. It's still mute, Prof.
Okay, thank you so much. I'm just going to share my screen. So I think you can see those slides now. Yep, can everybody see that? Right. So what I thought I would talk about, thank you. What I thought about, I thought I would speak about today is that we know that we're seeing a rise in AI in many fields and many laws, in fact, being enacted in different places around the world. Countries signing up to the Bletchley Declaration about AI safety. I thought I would talk about what's happening for people who are practicing law and the impact of AI on the practice of law, which is clearly very important given that lawyers will be doing some of the enforcing of these new laws. So that's the topic for my talk today, and I'll leave some time for questions at the end. Before I begin, I'm just going to once again thank you for inviting me to speak. This is my second time speaking, and the university has such wonderful students. I'm very pleased to be here. They're just exceptionally good. So I feel very honoured to speak. And I'd also like to recognise that I'm in Australia at the moment, in Melbourne, and acknowledge that I'm on the lands of the Wurundjeri people of the Kulin Nation. Pay my respects to their elders, past, present and emerging. And if you give me 1 sec, I'm going to grab my phone so I can keep an eye on my time or I'll talk too much. So, right, I'm back again. Don't want to go over time. So, as I've mentioned, AI is developing rapidly and being used in many applications. And I think we throughout the world were interested in AI in terms of machine learning. But now, of course, there's ChatGPT, and many people can gain access to ChatGPT through their phones, if I can get that in focus. There we go. Almost through their phones, and so it's literally at everybody's fingertips. And people are also using AI in the software packages often that they download on their computers. Many countries are enacting law to deal with the risks of AI. And last time I spoke about the risks, and I think we had some of the risks of AI in the previous session. So people are worried about risks of accuracy, bias. They're worried about risks to privacy, risks involving fraud, deep fakes used for fraud, and kind of inequality of access to the technology. So there's a number of risks that may be involved in the technology, and some countries are now passing laws to deal with those risks, and the most obvious one is the EU AI Act. And I know we've talked about this, just a little refresher. The EU AI Act has this kind of hierarchy of the requirements. So high risk, some systems are prohibited. The example's real-time biometric monitoring. Some risks are high risk, so that's decisions about access to employment or human resources. Then there's limited risks systems, so that might be chatbots, and then there's low risks, that's things like computer games. And most of those systems have requirements of transparency and they have greater requirements of transparency if they're high risk, as well as obligations to test the technology regularly to make sure it's not that it's still accurate and robust and that it's not drifting in its use. So be transparent, test the technology, and also have accountability processes in place. So that means a person or a team who's responsible for the use of the technology in an organisation. And other countries may not be adopting the EU AI Act, but many countries are thinking about variations on this. So Singapore, for example, has a scheme called AI Verify, which is not binding in law, but is asking companies with, for example, high-risk applications to still engage in those processes of testing, transparency and accountability. So that seems to be the pattern that we're seeing across the world in terms of managing the AI, though, as I've said, some countries are enacting law and some countries are leaving it as a matter of advice or recommendation. Now, obviously, most professions now are starting to be, their work is being impacted or influenced by the availability of AI. So tax professionals, accountants, artists, teachers, academics, lawyers are all being influenced by the use of AI available in their areas. For lawyers, this is particularly important, I think, because the lawyers are the ones that are also thinking and advising on to protect the rights of individuals and citizens that may be subject to AI, as well as advising companies and businesses and their own organisations about how best to make use of the AI. So it's interesting. It's an interesting time for the legal profession, and as an educator, it's a challenging time to think about the skills we need to impart upon our students. But the reality is that the very practice of law is now being influenced by the use of technology. And so what I'm going to talk about today is some of the ways in which people have been thinking about AI may impact on legal systems, the practice of law, and the act of judging, in fact. So you can see this outline of the topics that I'm going to touch upon. And if you like, you can see this as a case example of the bigger questions that many industries and professions are facing with the input of AI, but with special resonance, I think, for lawyers. So let's start. So the first issue is a lot of people at one time talked about robo-judges. Oh, maybe robots will replace judges. Judges being the people who decide the application of the law. There's not going to be robo-judges. So I'll just say that. There's not going to be robo-judges. We might use AI for small claims, for small amount disputes. And in fact, some companies kind of already automate disputes. But there's not going to be judges making, applying or interpreting the law that are robots or that are AI entities. And at least in Australia, but some other countries, judges have said this, but also tried to think carefully about why judges or magistrates or senior decision makings in the legal system won't be replaced by AI or robots. And generally, that's because what AI is very good at is making sense of large amounts of data, so finding patterns in data, and then using that to make predictions or recommendations. Generally, what judges are doing involves looking at evidence and thinking about what the evidence shows and inquiring into what happened in particular cases or the details of particular laws. Generally, people who are making legal decisions are using a great deal of judgment. They're using their wisdom, their knowledge about the world, their legal training to reach an outcome or reach a finding or reach a piece of advice. And that's the sort of thing that actually AI can't do and is unlikely to do anytime in the future. So if we think about a lot whether individuals' jobs will be taken by AI or whether they'll be replaced by AI, judges are an interesting and useful example because the skills that judges have indicate that they won't be replaced by AI. And I think we can extend that to lawyers as well, just as we can extend that to teachers and nurses and childcare workers. So AI is not taking people's jobs at this point in time, but it is changing the way they do their jobs, and we can see that in the law. So now this is turning now to how lawyers might use AI. This is what you can see on the screen. This is for people practicing law. What you can see on the screen is a survey done by Thomson Reuters in 2023. And the survey was primarily, this particular survey was primarily US, Canada, but it asked people what technologies help you in your role. And you can see that people thought that, know-how and precedent, automation are quite useful, but they didn't think that generative AI, ChatGPT, was useful. And you can see that on the low or the middle right side of your screen, you can see only 3% of the people surveyed thought that ChatGPT would impact on the way they did their jobs as lawyers. That was last year. If you go to this year, which I'll turn to in just a minute, you'll see that that has changed. That has changed everywhere. So my point is that judges and lawyers won't be replaced by technology. Some people think the technology is not relevant, but increasingly it's changing the way lawyers do their jobs. So let's think about the way it might impact on lawyers and judges and other people in the law and how they do their jobs. So let's start with thinking about how generative AI, so I'll take that particular technology, applies in courts and legal decision making. And what we see is that while courts and judges and legal decision makers are not being replaced by robots or AIs, they are thinking about the way they might use that technology. So here's a statement from Chief Justice Sundaresh Menon, who is in the Singapore courts speaking at a conference in India. And you can see that the Chief Justice thinks that AI is tremendously useful in decision-making and should enable judges to surpass human limitations. And indeed, the Chief Justice says AI might prove to be indispensable in dealing with technical, evidential and legal complexity that they see in cases before the court at the moment. And I think that statement from the Chief Justice is really interesting and useful, and again, tells us something about the practice of law, that the practice of the law is increasingly complex, and lawyers are the people making decisions about how other people use technology, and as well as, ordinary disputes about tax and companies and the like. And the idea is that technology can help with some of that decision-making, even if it's not replacing the decision-making. So often we talk about augmenting human judgment, but not replacing human judgment. And I think that's probably the theme of the talk. So asking ChatGPT to summarize complicated information, or using a database to understand the trends in large volumes of information, or perhaps using a document, a tool to review documents and find common clauses in contracts. All of those things are helping with the quality of decision making. And we see a similar pattern in law firms, at least in the countries that I've looked at. And I'll be interested to hear your views later on about what's happening where you are in Indonesia. So remember my earlier comment, last year, legal professionals thought that generative AI was, well, sort of not that useful. This is a new report by Thomson Reuters, which is the future of professionals in Asia and emerging markets. So this report surveyed not just legal professionals, but also accountants and tax professionals about what they thought the big transformational moments were in their areas. And that you can see in the space of just probably 8 months, that the professional surveys thought that if you think about what's transformational in practicing law, advising on law, giving tax advice or giving accounting advice, that the prolific use of AI and large language models is very significant. So that ranked very highly as the changes that will have a significance on the way those professionals do their jobs. And it was only after that that they ranked the economic recession, explosion in data, ESG, and so on. So technological change was significant. I do like the one at the bottom. So if you look at the bottom, what is impactful in the way professionals do their jobs? Millennials moving into leadership roles. And I'd love, millennials are people, I think, who are in their 30s. And it'd be interesting to know how many of the people who are watching this now are in their 30s and are the millennials, because you're making a big impact on business. But you know who's going to make even more of an impact? The people who are in their 20s, the next generation. They're really going to make the big changes because they're the ones who are growing up with the technology. So for those of you who are in your 30s, you're going to be a big impact. For those of you who are in your 20s, you're the ones who are going to be running the technology. So well done to you. And for people who are older like me, we're just going to retire somewhere by a beach, hopefully. Probably can't afford to, but, you know, we can think about that. All right. So what does this change mean? And what does it mean for how we practice law? I think I've talked a little bit about that, but also what does it mean for what's called, I guess, the ethical practice of law, or how do we bring ideas of responsible AI that we see informing things like the EU AI Act, this idea that if you're using artificial intelligence, it should be ethical and safe and responsible. How does that impact on what we're doing with technology and legal practice? So, specific concerns for the law now. There's a number of issues that arise through the increasing use of AI, and I'll talk about, and it might be generative AI primarily, or technological assisted document review, or contract automation tools, or all of those things. What are the issues for the law? Well, the first issue is the issue of privacy and data protection. We know that increasingly if companies are holding data about, or businesses or law firms are holding data about the people that they deal with, those are vulnerable to privacy breaches, hacking, the stealing of the data. So privacy and data protection remain huge concerns. There's a case there, I think I spoke last time, about digital identity to try and reduce the amount of data that's collected. And then there is the size of the investment. For law firms or any business that wants to embrace AI to improve its processes, to make its internal processes more efficient, to communicate with clients better, to give its employees and lawyers an edge in knowledge and expertise, it's a pretty big investment, actually. There's training, there's developing the processes to manage the new technology. And then there's the purchasing of the technology. So it's a large investment for people thinking about doing that. It's a large investment for universities. And there's a real question about whether they should do that now. Is it time to invest heavily in AI now? Should we wait until the technology is a bit better? And if we wait, will we be left behind? You know, will other universities, firms, companies, businesses get further ahead because they're able to use the technology? And I think that is a really difficult question at the moment. I can't give the answer, but I think that is a really, really big question for lawyers as professionals, but also other businesses and professions. And then there's the question of accuracy. So if we're thinking about using technology such as ChatGPT, and I'm going to talk about that a bit more in a minute, or any other legal technology, there's a question about the accuracy of that technology, because there's no point investing heavily in technology to help lawyers do their jobs better, or to help lawyers interact with clients, or to help lawyers write letters or review documents if the technology isn't accurate. Because if it's not accurate, then we would be better off keeping people doing those jobs. Technology can do human-like tasks, but not if it's less accurate than the people doing the tasks themselves. So the accuracy question is really important. So I'm going to talk about that now. I'm going to talk a little bit about generative AI and the question of accuracy. Now, I don't know, I'm going to talk about generative AI. There's lots of technologies that are being used in the law. So there's tools now that can help lawyers check lots of documents for particular words and phrases. There's tools that can help lawyers draft contracts or pleadings or other legal documents. But I'm going to talk about generative AI. Generative AI is ChatGPT. And it's a tool that's increasingly available. And what it does is it's a technology that's been trained on lots of text on the internet, and has been trained on large volumes of text so that it is able to respond quite well to human questions, at least in English, and provide answers on questions. At least it's pretty good on factual questions. It's probably less good on other sorts of questions. And it can produce quite fluent outcomes. So it can write quite well in English and some other language. So it's quite a useful sort of tool. And it'd be interesting to know how many of you have used it or have thoughts about it. At least in Australia, and I know in Singapore and Vietnam and some other places, and you can tell me about your country, people are playing around with it and sort of thinking about whether it would be useful in law. And the reason they think it might be useful in law is that it just summarises material. So it can summarise some legislation or an act. It can summarise if you're in a common law system case law. It can summarise recommendations from government bodies. And it can also produce letters and advices, at least in some form. So lawyers are thinking about whether and how they use this, just as students are. So here's some of the things that people are thinking they might be able to use generative AI or ChatGPT or Microsoft Copilot, depending on what technology you have. Here's some of the things they think they might be able to use it for in the law. And there, as I mentioned, things like researching, what is the law on deepfakes, or what is the data protection law in any jurisdiction? It can be useful for summarising. So please summarise the data protection law of India or Australia or Vietnam, or Singapore. It can be used for image to text work. So that's where an image is turned into a textual description. And you might think, why is that useful? Why is image to text useful? Well, it's useful in fields where people are dealing with very distressing images. So police, coroners, prosecutors are often faced with very distressing images of violent crimes or modern slavery or child sex abuse. And the idea that technology might help turn some of those distressing images into text could be useful to preserve the mental health of the people who are otherwise looking at those images. So that's why I've included those ones there. Generative AI is useful for first drafts, so first draft of letters, advices, written material. It often is quite fluent. Its spelling is good. If you're not writing in your first language, or if, like me, you're just not very good at spelling, it can be quite useful. Generative AI can help draft answers to email queries, and it's got a good search function if you don't, if you can't find a lot of, I'll start with that one again. It's got a good search function. So a number of organisations in Australia are using generative AI to automate their policy database. So the university that I'm at has a lot of policies about just about everything. It's got a policy about travelling overseas. It's got a policy about assessment. It's got a policy about teaching hours. And one of the things that's happening is that this AI is being used to have a search function for policies so that people are able to ask, what is the policy on travelling overseas? What is the policy on late assessments or so on, and that those policies can be retrieved quickly and efficiently and summarised rather than having to look through lots of documents to find them. So quite interesting uses being proposed for this technology in running businesses and legal practices and the like. But one of the issues is that people are very, very concerned about, I mentioned this before, the accuracy of generative AI and ChatGPT and the like. And it's very hard to get a handle or to understand how accurate this technology is. So there was newspaper reports last year that ChatGPT could pass the US New York bar exam. And apparently the New York bar exam is very hard, and somebody used ChatGPT to see if they could pass the New York bar exam, and they could, and they got quite a good score, which seems very positive. But last year also, there were news reports that some attorneys, some lawyers used ChatGPT to draft some filings to go to court, and ChatGPT created cases that didn't exist. It made up some cases that were used in those pleadings, and the lawyers were in fact fined because they'd misled the court. The case names looked quite realistic, but the lawyers hadn't checked them, so they ran into lots of trouble. So, you know, we're sitting between these two extremes of, well, is it useful, can pass the bar exam in America, or is it not useful that it makes up case names? That idea of making up case names is sometimes called hallucinating. So famously, ChatGPT hallucinates. Now, the reason ChatGPT and other generative AI hallucinate or make up names is because they're not sentient. Generative AI is not a human. It has no concept of truth. It has no concept of malice. It has no concept of doing the right thing. It's simply a language generating tool. And essentially the way it produces outcomes is it's been trained on lots and lots of English language documents and some other languages as well. And it's effectively formed word clouds so that it knows that if you use one particular word, another word is likely to follow. So, for example, if you use the word federal, a word that often follows federal is federal court. You can see that on the screen. Or if you use the word bar and law, bar exam often follows. So it learns associations of words based on word clouds, but that means it has no idea of truth, and sometimes it just goes down the wrong pathway because it's got the word associations wrong. And those still look very realistic, which is why people are worried, because unless you go and check, it's hard to tell the truth from the not truth. So does that make the tool possibly not useful at all? That's the dilemma. Now, some people in the US did a study on the accuracy of ChatGPT in producing legal information in America. Now, ChatGPT is trained on American content, US content, so it's probably most accurate for US content, less accurate for, say, Australian content or ASEAN content. And these people who did this work, now this is with quite an old version of ChatGPT, so ChatGPT changes its numbers as it becomes more sophisticated. So GPT, which is the underlying model, 3.5, went out to 4.5, so it's much better. But anyway, they found in their testing that legal hallucinations were prevalent, occurring with GPT 69% of the time, 69% of the time, and higher with another model. And what those researchers also found is they found that legal hallucinations were higher with less popular material. So older court cases from smaller courts, less important courts. GPT was quite good on recent case law. So in America, the highest court's the Supreme Court. Obviously, GPT was quite good on recent Supreme Court cases, but less good on older cases from state courts, for example, which isn't surprising, because what we know if we ask ChatGPT a question, is it's good on factual questions asked often. It's less good on questions asked less often. So if I say to GPT, how far is it to the moon? It knows it will give the correct answer because that's a factual question asked often. If I say, how far is it from my house, Jeannie Patterson's house, to your university in Yogyakarta, it won't know the answer because it's an unusually asked question. So it's good on popular questions, less good on unpopular questions. So it's not surprising that the legal accuracy varies. So is there anything we can do about that? Do we just chuck ChatGPT and other generative AI out, or does it remain useful for the practice of law? Obviously, accuracy is really important to lawyers, right? And there's a number of ways that tech companies have tried to respond to this problem of inaccuracy to make the generative AI more accurate and more useful for legal practice and other applications as well. One of those is training. And I don't mean training the AI, I mean training people using it. So generative AI works best if you ask quite specific questions and ask lots of specific questions to construct an output rather than asking one question. So if you say to ChatGPT, write an essay, it probably will do a bad job. But if you say to ChatGPT, please write me the introduction to a letter to the dean or a judge or a client and have the following things in it, it will do a much better job. So it's better with precise instructions over small concepts, if you like, or small contexts. The first one is train people how to use it. The second one is technical responses, which I'll talk about shortly. So try and improve the technology, which I'll talk about. And the third one is to have guidelines and policies about where, when, and how the technology can be used. Now, I think the last one is probably the most important one. So I will come to that in a minute. So training the lawyers. It's important to train anybody who's using the technology about its advantages and limitations. And sometimes organisations talk about the problem of shadow IT. And shadow IT is where people in a law firm or people in a business or people in a university aren't supposed to use technology, but are using it anyway. So they're using ChatGPT on their phone at home because they don't have an equivalent technology at their workplace to be able to do it. So shadow IT, we need to train people to say, actually, this firm, this business, this workplace doesn't use generative AI because of the problems of accuracy, because of the problems of privacy. So please don't use it at all. And if you do use it, tell people. And this is an interesting question for universities, actually, and Australian universities anyway are spending lots of time thinking about, one, how they preserve the integrity of assessments. So we don't want assessment done by a AI. We want students to do assessment, but also an interesting question about whether we should be training students about the limitations of the technology so that they can use it well, not badly. So that's training. That's the first response to inaccuracy. The second response to inaccuracy in these technologies is there's some technical responses. So people who provide legal technology, or OpenAI that provides ChatGPT, or Google and Microsoft and the like, or providing generative AI products, are putting a lot of work into making them more accurate. So the first one is prompt engineering, which is where they basically test and reward the AI for correct answers and discourage it from making poor answers. So that sounds a bit like you're training, I don't know, a puppy or a child to do the right thing. But literally often they'll be going through and asking a set of 50 questions every day and rewarding or giving encouragement to where answers are correct and then re-engineering the technology where it's incorrect. The next response, plugins. Plugins is a funny word, but what it means is basically connecting the generative AI to the internal documents of the law firm or the court or the university, so that instead of drawing on the whole of the world to find a particular answer, the generative AI is looking through those documents to find the answer. So it's less likely to get things wrong because it's looking at a smaller body of material. And then a related, but not quite the same, response is called fine-tuning or retraining, which is where a provider of legal technologies, so some of the big legal providers, take ChatGPT or a product developed by someone else and retrain it on specific legal material. So they're not plugging it in. It's not the whole model being told to look through some documents. It's actually been retrained on the legal material of the particular jurisdiction which it's going to be used. So retrained on Singapore law, retrained on Indonesian law, retrained on Australian law, so that when it's being asked questions, it's got a very rich, nuanced body of information available to it that's relevant to the jurisdiction and the discipline it's being used in. And I think that's quite an interesting response. But it's very, very expensive to do, very expensive. And if you go back to my comment earlier about is the investment worth it? I think we're still working that out, because if it's very expensive to refine or retrain an AI, then we might be better just using our own human brains rather than spending that money. It's still an uncertain question. It doesn't, also, just to go back to that point, it doesn't remove all problems of inaccuracy. So the technology still can get it wrong, because, as I explained, generative AI doesn't understand the truth. It's just finding patterns in and associations in words. So even if it's been retrained or refined on specialist legal material, even if it's been told to look at particular documents, it still can get things wrong. So then we go to AI use policies. So this is the idea that firms, universities, businesses, courts are using AI, generative AI, but they're having policies about where and how that technology can be used. And generally those policies cover things like transparency. Anybody who uses generative AI or their assignment or to write a letter has to tell the person they're reporting to that they're doing that, so that it can be specially checked. They have to be careful about intellectual property and privacy. There are still concerns that generative AI, which is trained on data on the internet, may infringe some people's IP or reveal sensitive personal data. That means there has to be quite a bit of oversight over the use of any technology that's being regularly drawn upon in legal practice. And it also means ongoing testing of the technology. A lot of firms in Australia who are using generative AI are simply testing it a lot, running spot checks, asking questions to see how accurate it is or whether there's any problems emerging, and then they can try and respond to those or narrow how much it's used. Whoops. And I think actually that's the end of, I've come to the end of what my slides. So what I wanted to then say in all of that, and I'm going to go back to that very first slide about law, is that there are a number of risks in AI. I mentioned them before. They're things like inaccuracy, fraud, and bias. Those risks are not going to stop us using the technology, us as lawyers or us as business people or us as students. We are increasingly using it because it's more widely available. The risks don't go away. The risks can be addressed to some extent by the technology, but they mainly need to be addressed by the humans. So those ideas of training and policies about AI are very important. And that's really the impetus behind the legislation that's being passed in various parts of the world, is to make sure that the technology that is used is as good as it can be and as safe as it can be, so that the harms don't fall on particular cohorts or people. What does that mean for us as individuals? My suggestion is that we should be engaging with the technology. We should even be having a go at it if we can get access to the technologies. Have a go, see what it does, understand what it does, because that places you in a better position to be able to give good advice about the use of technology, to decide where you want to use the technology, and also to put in place precautions against the various sorts of harms. And I'll just make one more comment about those harms. I think everywhere in the world now is aware of the harms of, we were worried about bias and privacy, and now we're worried about the harms of deepfake technology. I don't know how many of you looked at the pictures of the Met Gala ball that was on the other night in America. Some of you might have, some of you might not have. But there were deepfake images of celebrities and costumes almost immediately coming out. So people are using this technology for all sorts of purposes. And it's getting increasingly hard to tell what's true from what's not true. We all have to be responsible for that, but we're only responsible if we understand the technology and understand the ways in which we can make the technology more accurate and also more safe. So that's the end of my talk. And what I was hoping now is that some of the wonderful students at the university and elsewhere might ask some questions.
Okay, thank you very much, Prof. Jenny, for the presentation. It is very insightful, and it also answer our worriness, because I think Prof. Jenny opening remarks is very insightful, that AI will not replace a judge or lawyer. However, it will changing the way we as law scholars do. And there are some points that I would like to underline about her presentation, that this AI also arise some specific issue like privacy and accuracy. However, we should be engaged with AI because it is very useful for us, especially for doing researching, summarizing, imaging the text, writing the first draft, email management, and so on. And I think we're going to have a question and answer section from the participant. If you have a question, you can drop your question in the chat column, or you can ask directly to the Prof. Jenny.
That was a really good summary, by the way. That was an excellent summary, more articulate than me.
Thank you very much, Prof. Jenny. Okay, there is a raised hand from Mr. Trisno Naibahot. You can ask directly to Professor.
Okay, thank you very much, ma'am. Excuse me, Madam Professor. This is good chance to understand about how important artificial intelligence for the law firms and the activities in our lives. Even it was very good to know at the legal accuracy. But in the sometime in the moment, artificial intelligence has usefully wrong directly. I mean, some people made artificial intelligence as the weapons to do criminal, such as like the people do the cheating and making and made a cheat. I'm sorry, I need a little time. Made a cheat and make a transaction illegally. Like you put a link for the wedding or put a package from the courier, but when you click it, your money has been taken away. In the other hand, your handphone has been use the money, I mean e-banking on there. Oke, mungkin saya coba bahasa Indonesia sedikit ya. Excuse me, can I speak in Indonesia? Ma'am, sorry ma'am.
Okay, I will translate it. Yeah.
Oke, begini ma'am. Sederhananya begini ma'am. Kita ketahui bahwa artificial intelligence ini sangat berguna untuk kehidupan kita, termasuk dalam hal kebutuhan untuk keperluan penindakan terhadap hukum. Memang dalam Undang-Undang Nomor 1 Tahun 2024 di kami ada namanya perubahan atas Undang-Undang tentang transaksi elektronik, yang mana masih sebatas tentang tanda tangan elektronik sendiri. Di sisi lain, perkembangan AI ini semakin kencang dan memudahkan banyak orang untuk melakukan kejahatan. Misalkan dalam WhatsApp kita ada sebuah aplikasi phishing namanya kegiatan tersebut. Ketika kita klik aplikasi tersebut, tiba-tiba saja uang kita kesedot oleh karena adanya perbuatan ketika orang tersebut melakukan penipuan. Biasanya kan penipuan kan melalui telepon, ini melalui sebuah aplikasi. Ini maka datang ke undangan saya atau klik ini, maka paket akan sampai. Tapi ternyata kegiatan phishing masih rawan terjadi, dan itu terjadi dalam transaksi elektronik yang ranahnya AI. Kami akui bahwa negara ini sendiri tidak memiliki undang-undang atas artificial intelligence karena artificial intelligence sedang menemukan payung hukumnya. Dan menjadi pertanyaan terbesarnya adalah apakah bisa kami selaku masyarakat milenial ikut juga bertindak dalam hal mengurangi kejahatan atas AI tersebut, karena AI tersebut di sisi lain juga bisa merugikan kehidupan kami juga. Misalkan setiap media sosial ada di online, itu yang sedang kami perangi. Di luar sudah berhasil melakukan penindakan terhadap pelaku-pelaku jika menggunakan AI dalam melakukan perbuatan pidana. Itu yang mau saya sampaikan. Terima kasih.
Thank you very much, Mr. Trisno. So Mr. Trisno is actually actually gives us an example, like there are some phishing chat, especially in WhatsApp. If we click it, and that suddenly our money in our bank account will just run out. And his question is, how come we in Indonesia combat this kind of crime, and how come we deal with the crime using AI? I think that's the main question.
Okay, so I'll have to answer in English, I'm afraid, but the use of AI for scams is growing, and one of those scams is to send someone a payment link or demand a payment, and then they click on the link and the money goes to the wrong place or goes to a fraudster. There's also scams using deep fakes where it appears to be a person that you know, where in fact it's not, or using the technology to create a synthetic voice. In Australia, we've got a problem with children ringing their mothers. So I have children, I'm a mother, children ringing their mothers saying, "Mum, I need you to send me some money," when it's a fake. So the scam issue is huge. There's no easy answer, but there's at least 3 things that we need to do. The first one is education. Australia now has a scam centre which provides updates and information about current scams so that we hope that people don't get defrauded to the same degree. So, for example, in the payment scam you mentioned, in Australia, we're told you should ring first, ring to confirm payment link or use one. The second approach is to use technology itself. So it is possible to use AI to identify common scams and also, in some cases, stop money flowing to known scam accounts. So that's the second one. The third possibility is something I spoke about last time, the third element of that response, which is digital identity. So, and I believe Indonesia is looking at digital identity. So digital identity gives a unique digital identifier to every citizen, and that identifier is used to verify they are who they say they are when they're transacting online, and also reduce the amount of personal information that has to be shared, because of course if individuals are sharing personal information, their identity can be stolen and then used for further fraud. So 3 possibilities for that online crime, which is the education of the public, using AI to identify scam messages and scam accounts, and then thirdly, digital identity is a way of verifying identity online and also reducing sharing information. No easy answer. So it's a good question.
Oh, so thank you, ma'am, for the question. But I will ask some more questions. We having a good time to learn about the technology based ourselves, but we are already knew that we had learning cyber law, but not in our semester, not in the teacher, but maybe 2 or 3 years ago in my campus at University of Medan area. Are we sure to learning about the cyber law in the front line as the quick suggestions to the crime when they're using AI? Thank you very much, ma'am.
I think what you're asking is whether whether cybercrime, cyber protection should be part of the student study. Is that right? You want more subjects on that?
Yes, just want to know because the study of the cyber law has been or we call in Indonesian name hukum siber. It has been began at the 7th semester or 6th semester also, but I mean there is a 2 or 3 years to learning ahead. But for this current situation, we have to know about the many regulations, but not sure about the cyber law if we're learning again from the beginning. So are we going to learning cyber law in the first or maybe in the 3 years since activities because AI are speaking up so quickly? Thank you very much.
Well, I think I don't have an answer. I think it's a really good question. In Australia, the problem that we have is that we don't have enough cyber professionals to teach the material. So there's a real gap between what's happening out there in the world with cybercrime and the ability to teach the material and in fact train people to respond. So all I can say is I think that we need to see more education as well as stronger responses, but we almost need to train, we don't have enough people. There's a real shortage of cybersecurity experts at the moment. And cryptography is another field. We need more cryptographers. Cryptographers are people that put kind of a code on data to keep it safe. It's really important in online transactions. We don't have enough cryptographers. So you're right. We need to build more expertise in this area. It's quite slow at the moment. Yeah.
Okay, thank you very much, ma'am. That's all my question. Thank you.
Thank you. Thank you for the question.
Thank you very much, Mr. Trisno. One more question from the participant, maybe. Okay, Rota, you can ask directly to Prof. Jenny.
Thank you so much, Prof. Jenny, for the presentation. I'm Rota. I'm from Madagascar, an international student at UMS. First of all, I would like to talk about the context at university. I think that as we are all law students, I think it's a good idea to integrate AI law as a subject in the faculty of law. And even we have to give the students the skills to use AI legal tools at university so we can use it correctly. But I have another question, which is a little bit related to my experience as an international student from Madagascar. So I traveled to another country, and Madagascar is an island in the south of Africa. So I'm going to focus on my research dissertation of PhD, which is about immigration law and AI. So we have a challenge here because, Madagascar is in the African continent. So it means that, we are African then. And whether it hurts or not, most of the time, African people are discriminated at entry checkpoints at the airport. So that's the problem. And the thing is that nowadays, most of airports in developed countries or I don't know, I've never been there so far. And I don't know, like US and especially Singapore, where I went, I was struggling, because even if we are watching some social media video who are posting some African people who are on detention at the entry point, there are AI used by those airports. And, I don't know, but they are classifying directly you as a threat, I don't know, or as because of discrimination, So when your I don't know, your origin or your passport is not US or I don't know, France, I don't know, it is directly classified as a threat to their national security or I don't know, like that, something like that. So I think we have to raise this issue, like we have to deal. I don't know what to do because the use of AI can be good, but when they are leaning, they depends on AI decision in classifying the types of applicants to enter their territory. So there's no discussion anymore, but when this is from this and those are the information about this person, so directly it is a little bit suspicious. But when it's about this person, this person is from this country, so it's okay. The entry is going to be smooth. Thank you. That's my question.
No, it's a really good question. So on the question, you had two questions. The first one is, how do we educate students about technology? I think we need to start integrating this into the curriculum. It's hard because technology is changing so fast. We don't, the time you all graduate, the technologies will be different, but we should be having the conversation. The second part of the question was about algorithmic discrimination, and it is widely documented that a lot of AI systems discriminate against people with darker skins, women and people with darker skins. And it's uncontroversial, and it's because the training data is either comes from, you know, white affluent countries, or in fact, the training data is itself biased and discriminatory. And facial recognition technology, which is used at a lot of entry gates into countries, will often suffer from that problem. It's less effective in identifying people with darker skins than people with lighter skins. And the sort of security flagging systems that you were talking about often contain inherent biases about who's a threat and who isn't a threat. So what do we do about that? As an individual, there's very little you can do. As a lawyer, there's more you can do. And as an academic, there's more you can do. That's why ideas of responsible AI, however they're designed, I'm very concerned about algorithmic bias, and why I go back to my point, we need to understand the technology to be able to explain why it's sometimes unfair and how we can work against that. So if you're doing a PhD, I can only say, well done to you. That's great.
Oh, that's very interesting. Especially about the responsible AI. Okay, participant, do you have any question? We still have one opportunity, one question if you want to ask for Prof. Jenny. Is there anybody who would like to ask to Prof. Jenny? Okay, I think that's all, Prof. It is a very insightful discussion, but before I close this forum, would you mind to give us like a closing statement?
Sorry, what?
Would you mind to give us like a closing statement?
Oh, a closing statement. Yes. Well, my closing statement would be that AI and in its various applications is here to stay. And I'd recommend that everybody educate themselves in how it can be used and the limitations, and that they think of that as part of both the way they will practice law and the way that they will act to protect rights in the law. And I think that's what I would say. Use AI for good depends on people like you making the decision to fight for that or advocate for that.
Wow, that's very great. So actually, AI is very depends on who uses it, right? Okay, I think we are reaching the end of our session. I would like to express thank you very much for Prof. Jenny. It's an honor for us to have you.
It's lovely to come and see you. This is my second talk, and it was always to speak.
Okay, thank you very much. I hope that this is just the start of our collaboration. I think we can meet in another opportunity or other collaboration. Thank you very much. And dear participant, here in the chat, column chat, you have the attendance list for this event. Please ensure that you write down your name properly. I think this series of discussion is end with Prof. Jenny presentation. We have started with Prof. Trisa, and then followed by Prof. Chen, Prof. Aidul, and Prof. Jenny. And I hope that this series of discussion will bring a lot of benefit for us and will give a deeper understanding, especially for us, especially about the AI itself. Thank you very much. I think we reached the end of this event. I will give this forum to the MC. Okay, thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Okay, thank you, Mrs. Hanifah, and also all of the speakers here, ladies and gentlemen. Now coming to the last agenda, there is closing. But before closing this program, I am as the master of ceremony. Absolutely, I have many mistakes. I do apologize. Thank you very much for joining this event. May God bless us forever. The last I say, wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam
Warahmatullahi wabarakatuh.
And now, announcement for all of the presenters. After taking a break until 1 past 45, please join this break. Please join the breakout room for the parallel sessions. List of the chamber already distributed in WhatsApp group. Thank you. Hello. So you can join the breakout room. You can find the breakout room after click more in the toolbar below. Then after that, click join breakout room. Then choose your chamber. The chamber is already distributed in WhatsApp group.
Right, can you
You can join the chamber now.
Excuse me. MC. I would like to getting my absentee, please. I mean the link.
Absentee?
Yes, I
Oh,
need the absentee. Yes.
absentee for participant?
Yes. Yes.
It's already in the column chat.
Oh, thank you very much.
Yeah.
Excuse me, you mean we have to click where and then join the chamber? How to do it?
First, you can click more in the toolbar below. More. You can find it.
Yes, yeah, thank you.
Piye lagi?
Terus rendeng aku gak iso.
Kecil ya?
Email.
Never in this. No. Maybe. Một lần sao? Đang thấy lợn. Tại biết luôn rồi. Sẽ có cho用vào trong. Então,
Isso.
aqui.
Tunggu. Emailmu. Emailmu ya.
Thank you. Yoi.
Astagfirullah.
Apa passwordnya?
Passwordnya nganu. Bintang. Ini gede. Bintang 1466.
Salah no
Bintang 2002.
Salah.
Apa?
100.
Mute dulu, Mas. Pero.
udah ikut mas. Cara masuk ke chambernya. Ini mas caranya gimana?
Ada Mbak di sini. Kalau aneh ya. Megang apa-apanya? Enggak, aku udah tadi. Enggak.
S2 ada yang presentasi nggak?
Terlalu dekat.
Iya, nanti di nggak apa-apa, sementara kan belum mulai kan.
Masuk ke member itu udah. Oh, bukan.
Oh, wifi.
Ya Allah.
Enggak belum ada. Tapi udah benar.